All right, welcome back to the Judiciary Committee afternoon. We have a really big topic ahead of us towards the end of the agenda, and the immediate item we have on our agenda is the crime data reporting. But we are very convinced that we will find a way to get all these big conversations in within a good and reasonable time. With that crime reporting, we have a presentation from our very own Representative Washut.
Thank you, Mr. Chairman. If we want to go to my slideshow and just share the slides. What my objective here in the next few minutes, and I will be brief so we can move along, is simply to set the table for this afternoon's discussion, to remind everyone about some of the issues surrounding the NIBRS data collection system that we talked about in September, so that we're all on the same page as we move through the rest of the discussion today. So crime data are valuable for a number of reasons. Number one, for our concern as a committee, is formulating public policy. Without good data, policy suffers. So that's our first objective. Number two, we can evaluate and assess existing programs based upon data that we can't do without data. We can justify new programs when we have good data. We can identify statutory changes that may be necessary when we have good data. And we can develop grant funding requests, or at least the agencies may be able to develop grant funding requests because they have good data. So I included in my presentation just a bunch of acronyms for those who aren't familiar with them. We'll be using just a few of these today, probably not all of them. The FBI has historically tracked crime using three systems: the UCR SRS, the Uniform Crime Reporting Summary Reporting System, the Supplemental Homicide Report, and now NIBRS. The Bureau of Justice Statistics within the Department of Justice conducts what they call the National Crime Victimization Survey, which gives us a look at data from another perspective. So just a few quick points about the FBI and summary reporting system. We talk about our clearance rates, and this is a measure of law enforcement success. It's based upon the number of arrests, not necessarily judicial outcomes. Clearance rates. We also notice that in the summary reporting system, only crimes that are reported to the police or to law enforcement are included in the data. That's where the National Crime Victimization Survey comes in, is that it picks up a glimpse, at least, of crimes that have not been reported to the police. Also within the summary reporting system, we had this thing called the hierarchy rule, where if we had multiple crimes that occurred simultaneously, only the most serious of those crimes would be reported. So for example, if we had a robbery and the clerk was murdered during the robbery, the SRS would record that as one murder, and the robbery would kind of be neglected or overlooked. Because statutes don't match state to state, burglary in Wyoming, burglary in West Virginia may not be the exact same elements in the crimes. The federal government gives us a reporting handbook with strict guidelines and definitions so that every state is putting in the data in the same fashion so we can compare apples to apples, state to state. So the summary reporting system focused on Part 1 index crimes. When you heard a newscast that said crime is up in America or crime is down in America, this is what was being measured: murder, rape, robbery, aggravated assault, arson, burglary, and larceny. Also with the summary reporting system, we use the reference to crime rates, and these are the number of crimes per 100,000 population, and that allows us to make comparisons geographically and or even historically within the same community as populations change. So the road to NIBRS, an interesting road. It starts long ago, clear back in the 1970s. It was the law enforcement community that approached the FBI and said, we need to think about doing something better with our summary reporting system than what we do today. So it began with a request from law enforcement. The FBI began formally studying the reporting system in conjunction with the Bureau of Justice Statistics in 1982. In 1985, they published their blueprint for the future. And in 1986, it was the FBI that was formally tasked with developing NIBRS. In 1987, South Carolina began the first pilot project using the NIBRS prototype. It continued to evolve. In 1988, the National Uniform Crime Reporting Conference endorsed NIBRS as a concept. In 1991, NIBRS is officially created. In 2011, NIBRS has its first set of data published with 5,800 agencies reporting, about 32% of all the law enforcement agencies in the United States reporting at that time. So 1991, NIBRS is created. That was a long time ago. Shows you how long ago that was. In 2015, the sunset of the summary reporting system was announced, and that took effect on January 1st of this year, meaning that the summary reporting system was no longer going to be used and all data needed to be submitted using the new NIBRS format. The CJIS Advisory Board announced NIBRS only deadline in 2016. In 2018, Wyoming received FBI NIBRS certification. And in case you were wondering why this deadline wasn't rolled back because of COVID, it was because so many departments are already well down along this road towards the evolution to NIBRS. So at this point, I'd like to switch over to the video. We have a short video produced by the FBI, which I think is instructive about this transition to NIBRS. When we're ready.
The year Babyface Nelson robbed his first bank, and Bonnie met Clyde. We got our news on the corner. Our mail came in envelopes. And our crime statistics from a new publication, Uniform Crime Reports for the United States and its Possessions. The year Babyface Nelson provided information on 7 offense classifications. We got our news on the corner. Our mail came in envelopes. And our crime... But even though multiple crimes may have been committed, only one offense per incident was reported. It was originally produced by the International Association of Chiefs of Police, but was shortly handed over to the FBI's Uniform Crime Reporting Program, or UCR. For nearly 60 years, the summary reporting system of UCR remained virtually unchanged. However, the volume, diversity, and complexity of crime steadily increased. In 1989, the National Incident-Based Reporting System, or NIBRS, was implemented. NIBRS collects data about victims, offenders, property, and arrests. NIBRS provides for 52 offense classifications with up to 10 offenses per incident. This provides a more comprehensive view of crime in the United States with greater flexibility in the compiling of data. NIBRS isn't just about names and numbers. It gives us a picture of the circumstances and who the victims are. Victims of domestic violence, identity theft, animal cruelty, and reports on cybercrime. Although the FBI has maintained both the summary reporting system and NIBRS for several years, the time has come to make NIBRS the UCR data standard. Therefore, the FBI has declared NIBRS a top priority at the recommendation of the nation's leading law enforcement organizations. The International Association of Chiefs of Police, Major Cities Chiefs Association, National Sheriffs Association, and the Major County Sheriffs Association, along with the CJIS Division Advisory Policy Board, have joined with the FBI to establish the goal of transitioning to a NIBRS-only crime statistics collection system. Many agencies have already seen the benefits of using NIBRS. Here is Colonel Ed Rosler, Chief of Fairfax County Police Department in Virginia.
So we started a journey back in July of 2013 to convert to NIBRS. So what we methodically did over the next few months was to work with all of our elected officials and all our media staff that cover the greater metropolitan area that I work in. We did a side-by-side comparison to help them understand why do some of these categories look different, but also to talk about the benefits of NIBRS, where we could drill down and have deeper discussions about how we could fight crime in our community and use this information.
Because of its value, NIBRS is becoming the data standard not only in large agencies, but also in smaller agencies. Here is Chief Luke Thompson with the Byram Police Department in Mississippi.
Our city was incorporated in 2009, and I was hired in 2010 to create our city's very first police department. We came into a community that didn't have a really well-defined problem. We knew that crime existed. We knew that we needed tools up front that would help us address those problems, help us to clearly define the problem. Came from an agency that was a NIBRS agency and saw how we used crime data there to solve problems and to fight crime in that city. So when we were looking at establishing a brand new police department, NIBRS was kind of on the forefront of our mind. We were able to fund some state-level technology grant monies that allowed us to buy some computer servers and to actually purchase the initial software. And once we got through that initial setup process and we got through that initial certification process, maintaining the NIBRS program has simply become an integral part of what we do.
Our plan is to close out summary reporting no later than January 2021. As a result, we will see an improvement in statistical reliability, accuracy, accessibility, and timeliness. We will provide training opportunities and technical assistance to help agencies with their transition. It is no longer 1930. Over the years, technology, like crime, has become more prevalent and complicated. Recent advances are transforming how the news media collects and broadcasts their reports. And a surge of social media has put instant reporting into the hands of anybody with cell tower or Wi-Fi access. We live on the same planet, but it is a new world. Our mail comes on the screen. Our news comes as it happens. And our crime statistics reporting must catch up with available technology and public expectation. The time to think about NIBRS was yesterday. The time to move to NIBRS is today.
Clearly in 2021, NIBRS will be the repository for the nation. We need the chiefs and sheriffs across the country to convert, meet the deadline, because we need to show the picture of crime in America. We need to be transparent and tell our story. We need to be able to compare ourselves to similar jurisdictions of our own size throughout the country, to have metrics to measure how are we doing and how, as local communities, states, and a nation, can we combat these epidemics of crime that we have throughout our communities.
Back to my slides. So there are some advantages, as the video indicated, about transferring. There are some advantages of moving from the summary reporting system to NIBRS. And most importantly, that has to deal with the comprehensive nature of the data that's going to be collected using NIBRS versus the statistical data summaries that we saw with the UCR SRS. So several questions come up about the transition to NIBRS. And first one we talked about last time was, are agencies required, next slide, are they required to participate in NIBRS? And if they're not, there are grants, however, that will require that all applications be submitted in the NIBRS format. So if an agency was receiving some of those grants, if they wish to continue receiving those grants, they're going to have to make the transition to NIBRS. So what happens if an agency doesn't participate? They will not have their data assembled as part of the national look at crime in America, and they may lose grant funding. So the FBI, I think, optimistically anticipated the transition to NIBRS would take an agency about a year to fully transition. And their thought was that as more agencies, more states became compliant, that the transition for individual agencies would be even quicker. Like I said, I think that's been overly optimistic. And then in terms of rural states, at least on the surface, it appears that the states that are surrounding us are already moving to NIBRS, and I'm sure Director will have more to say about this transition and what the data really say when you dig just a little bit deeper. So the big advantage of moving to NIBRS is the depth of the data that we're going to have compared to the summary reporting system. Instead of 8 Part 1 index crimes, we're going to have at least 52 data crimes that will collect a lot of information, and with up to 10 different crimes in a single incident. So NIBRS collects more robust data, which will give us all sorts of information that we can use, I think, as policymakers. I still hold out hope that it will also make our law enforcement agencies more effective. I really do think that once agencies find out how much data they have and what that might reveal to them, they may find all sorts of avenues towards more creative approaches to crime control. Well, I think that's enough to kind of set the stage for us, Mr. Chairman, and move on to the rest of the discussion.
All right, very well. Committee, do you have questions for Representative Washit? Co-chairman?
Thank you, Mr. Co-chair. Representative Washit, thank you for the presentation. Know that you have provided this information before to different stakeholders across the state as part of your former profession and likely current one now. Notably, on the 2 slides that I think I'm taking note of are the one of how long does it take to transition to NIBRS? And according to the slide, approximately 1 year to fully transition for an agency. And then the second slide after that is, do rural states lag behind in transitioning to NIBRS? And the answer to that is clearly no. And that in 2013, Colorado, Idaho, Montana, North Dakota, and South Dakota all used NIBRS. And that was, obviously in 2013. So very helpful information there. So thank you so much for providing that. And as we get to the rest of the testimony, those are the 2 slides that I've pulled out.
Appreciate that. We're still waking up from lunch. Okay. Do Gee, I just really hesitate to call the ECI up, but. But this is your topic. Well, you didn't, it's our topic, but I mean, you're the primary here.
Mr. Chairman, Madam Co-Chairman, members of the committee. Again, I'm Frosty Williams, Director for the Wyoming Division of Criminal Investigation.
Good afternoon, Kara Chambers, Attorney General's Office.
Allison Moore, DCI.
There we go. What I'd like to start with is give a overview since we last appeared in front of you folks back in September. I believe we have very good news to report. First, let me start, if I may, Mr. Chairman, Representative Washit, I enjoyed your slide show. That was excellent. I'm going to refrain from answering that. So we have done a lot since we last met with you folks. And I really want to give actually a big thanks to Deputy Director Allison Moore. We have reached out to all of the law enforcement agencies. We've provided an updated list that I believe all of you have. But before we get into that, one thing I want to explain a little more in detail is in reference to the slide about rural states. What we have learned, because I have reached out to my counterpart, the director of the Montana Bureau of Criminal Investigation, North Dakota Bureau, South Dakota Bureau, and Colorado Bureau. And yes, they are NIBRS compliant like we are. Some of those states, I believe, did become NIBRS compliant in 2013. Wyoming, we became NIBRS compliant in 2018. That doesn't mean, though, that all of the law enforcement agencies in those surrounding states are reporting it through NIBRS. Really some of what those states did is they said, either you send it to us in the NIBRS format and we forward it on, or you don't get forward, your data doesn't get forwarded to the FBI. That's truly what occurred. Out of our surrounding states, roughly 45 to 50% of all the law enforcement agencies in those states are NIBRS compliant. Wyoming, we are getting close to that. I'm not good at statistics, but right now we can say that out of 58 agencies, we have 40 of them that are reporting. 18 of them are currently not reporting yet in NIBRS, but they're in the process of getting there. Nationwide, the number, it depends on what statistical site you go to. I've talked to the FBI about this. The best numbers I can get are 38 to 40% of agencies nationwide are currently NIBRS compliant. Wyoming, I'm happy to report we're ahead of that. So the last time we met with you folks, one of the agencies in Wyoming that was not NIBRS compliant, and it was actually an agency that started off as part of the Wyoming test pilot program, was Park County. Myself, Deputy Director Moore, we've had a number of conversations with Park County, the sheriff up there and his staff. I'm happy to report that today Park County is completely NIBRS compliant. They are reporting, and they have gone back to January and have caught up on the reporting. And I think they have a much better understanding of why they need to report their data through NIBRS. And the sheriff assured me as late of yesterday that they will continue to be reporting all their data to us through NIBRS. You know, there's certainly hurdles with NIBRS. In the 30+ years that I've been in this profession, I have worked closely with the FBI a number of times. And I enjoyed the FBI's video. But I can tell you that it's not always as easy as they portray it to be. And when they say it may take an agency a year to become NIBRS compliant, I think that's very true. But what we have learned is that the biggest hurdles for law enforcement to become NIBRS compliant all come down to the vendor that they have in regards to their record management system. I don't think the FBI consulted with these vendors at length prior to pushing out the data fields that are being required. And there's been a lot of confusion. I can speak on my agency. We use a vendor that's relatively popular. It's called Sunridge Systems. We are struggling ourselves getting all of our data converted over to submit it through NIBRS. The biggest hurdle we have is NIBRS. I'm sorry, our vendor reaches out to the FBI and says, why can't we get this data field to work? What do you want collected in this data field? There's communications that go back and forth. And quite honestly, there's been confusion at times, and it changes. We are seeing it change less and less as time goes on, and it's starting to work. I do believe there could be some great benefits down the road to all law enforcement once all of these wrinkles get worked out. But it has been a lift. I can tell you, I think most of you would realize this, that the majority of the investigations that my agency does are rather large, oftentimes more complex type investigations. And it is taking our own people anywhere from 30 to 45 minutes to enter the data off of one investigation into NIBRS. Now, as we get better at it, that's being reduced in time. But I look at like large agencies, for example, Cheyenne PD, Casper PD, who deal with, I don't know, 30 to 50 calls in a 24-hour time period, if not more. I can see where it's a drain on resources to be able to enter all of this data. But what I'm happy to report, and we can go through this list in more detail that we provided to you folks, but I'm happy to report that I believe Wyoming right now, law enforcement as a whole in Wyoming right now is doing a good job at becoming NIBRS compliant. And in the conversations that Allison and I have had with chiefs and sheriffs and their support staff folks, I think it's only going to continue to improve.
Committee? Representative Yin?
Thank you, Mr. Chairman. So I probably should just ask this of my own chief of police, but I'm looking at your list, and Jackson Police Department has been approved as of August, but hasn't submitted any data. So that's on page 6. I'm just wondering, since you guys reached out to everyone, do you know what the reason for that one is? No? Okay, then I'll just ask my own chief of police.
Co-chairman, another comment?
Thank you, Mr. Co-Chair. Is there any federal assistance in working with the vendors that seem to be the source of all of these challenges that you're aware of?
No,
Mr.
I'm not
Williams.
aware of any assistance from the federal government to the vendors. They're answering their questions and talking to them, But as far as like upgrades to software that need to be made for the vendors, as of right now, I've not heard of any type of financial assistance.
Thank you, Mr. Co-Chair. Or maybe even just a strongly worded letter from the Department of Justice, recognizing that this really fulfills the mission of the DOJ to get these vendors more compliant and working with these agencies to make NIBRs actually functional, I think would be helpful. Maybe the Association of Chiefs and Sheriffs can ask some of those other federal partners to do that, as well as state DCI. Reach out with the federal agencies and try to get some cooperation there for some heavy lifting. I'm sure many of our state agencies, law enforcement agencies that want to be compliant or want to work in the NIBR system and can't, and have spent resources on it, are very frustrated. So certainly any assistance that they can get from all the different parts would be helpful. But you don't get that unless you ask.
Vice Chairman Washit.
Thank you, Mr. Chair. Director, I was wondering if you could go into that list a little bit. The very end of it was what caught my attention, the number of agencies that had never submitted, even under the SRS, never submitted data to DCI. Could you discuss that a little bit?
Mr. Chairman,
Director.
Representative Washut, yes. So this list, and understand this list on page 7, is we obtained the names of these law enforcement agencies through POST, Wyoming's POST certification. We felt like they would have the most updated information. Some of these police departments currently don't exist though, but these are the agencies that we have we've contacted some of them we still are in the process of contacting. Some of these smaller agencies, and I'll give you an example of Hewlett Police Department. Hewlett Police Department, I believe, is a one-person department, and they rely heavily on Crook County Sheriff's Office. I think there's been some confusion by the Hewlett Police Chief that he thought that anything that they dealt with, that the Sheriff's Office would therefore enter into NIBRs. And we're working with those entities to figure all that out. Some of these departments might not even deal with the type of data that needs to be entered into NIBRs. For example, Wyoming Game and Fish is possibly one of those agencies. So, but when we put this list together, we felt it was only fair to make sure we had every law enforcement agency listed, so we could provide that to you folks. On the last list we provided, none of that was on there.
We should probably delete the ones that don't exist.
We're trying to verify some of
Oh,
those.
okay,
Yes.
all right. Yes.
Thank you. On that topic, the Wyoming Highway Patrol is certainly an interesting agency. So where does their data go?
Madam Chair, I've talked with the Colonel. They are in the process of becoming NIBRs compliant. They recently bought a new record management system, and the system they bought is a system that is used by other agencies in Wyoming. So they know that they can get it, they can get there, they can become NIBRs compliant. I believe there was a time frame within my agency where mixed messages might have been sent saying state agencies do not need to become NIBRs compliant, which obviously that is not good. So.
Senator Cole.
Thank you, Madam Chair, Co-Chair. Just to update for Sweetwater County, I had spoken to Sheriff Grossnickel last night, and he informs me that they are NIBRs compliant currently. They are, in fact, going to catch up with all their reported documents by the end of next week. So just an update for Sweetwater County Sheriff Department. Thank you.
Thank you for that, Senator Cole. That's
Mr. Chairman,
good news indeed.
Sweetwater County, as of October 27th, became certified to submit through NIBRS. And then also next week, we're doing a training for 2 days where we have 3 agencies that are sending 12 people in to get training. We've had some of our agencies around Wyoming that have lost their record management staff. So they've lost all of their staff that were trained to submit through NIBRS. So we're hoping to help alleviate some of that with training next week.
Good news as well. Director, you said you were going to deliver good news to us, and you did. I think it's really good news that we're one, yeah, well, for a couple, but for a couple of locals and for one agency. Committee, any other questions, comments? Representative Washut.
Director, would you send us a photograph of yourself in 1991, please?
So kind of committee, back to you. This was in response to, the concern over hate crimes and those types of pieces. And the response to that was NIBRS is the solution because we're going to be able to track that data and get our arms around what is and isn't happening in Wyoming. So just kind of recircling it back to what this is. So maybe just hearing any feedback from the committee about where and if you want this conversation or any follow-up on the NIBRS compliance issue moving forward in the next interim potentially, or a report back to the committee in a period of time, 6 months. Any kind of conversation like that to keep you awake mid-afternoon.
Representative Yin.
Thank you, Mr. Chairman. I think this is great progress, and I'm glad to see that it's happening. And thank you for doing the work to reach out to all those agencies, especially the ones that, now that we even know there's a bunch of state agencies that haven't reported. So I think it's good that we're going to actually make the transition happen for everybody, which is great. And I do think it'll be good to put this as a line item for interim for the next year, just to make sure that we follow up to make sure it's actually happening. And I will also get on my own town's police department and see what's going on. Thank you, Madam Chair, Mr. Chairman.
Representative Provenza.
Thank you, Mr. Chairman. Yeah, I'm not sure how the highway patrol sorry, correct me if I'm wrong, any of you. Does the highway patrol get funded by Department of Transportation? And if I'm correct in that, then how is this going to look with the funding cut if highway patrol or if other state agencies within the state are not following NIBRS when we're talking about possible funding cut from DOJ?
Director Williams.
Mr. Chairman, Representative Provenza. So because Wyoming became NIBRS compliant back in 2018, and we are not currently being penalized for not having all agencies be NIBRS compliant. So because the Wyoming Highway Patrol is still in the process of becoming NIBRS compliant, I think the answer to your question is there would be no effect at all on the state of Wyoming.
Follow up, Mr. Chairman.
Go ahead.
So it seemed to me, and someone please correct me if I'm wrong, I thought in the last meeting that we had a new mandate that everyone in the state had to be compliant by January 1st of 2021. And so I know I had conversations with Ms. Chambers about that, so maybe she can clarify that.
Ms. Chambers.
Chairman, Representative Benza. Yes, correct. That was the information that we're given, that there could be up to a 10% penalty on specifically the JAG burn grant if we were in non-compliance. But what we have since delved into is that it doesn't require 100% compliance of every reporting agency, but our state is in compliance. And so I understand where the question came from, because that is the information that we presented. We were concerned about not being in compliance, but we've also found out, as Director Williams presented, that even of the 30 some odd states that are in full compliance, that doesn't mean 100% of their state agencies are in reporting. What we do, however, have is a error threshold on our reporting, and is it 4%? We have to maintain under 4% error. And so far we are managing that. It is worth noting that for the state of Wyoming and for all these agencies, DCI has one employee who administers the NIBRS program for our state. And she is in charge of working with every agency if they have a greater than 4% error rate, and going back to correct that. So that's obviously a full-time job, but I just wanted to note that, because as we bring more agencies on, it's a lot of work to make sure we have good data, but the NIBRS system is well worth the investment to get the data to be able to make policy.
Director Williams, make sure you tell her we really appreciate her. That's a lot of work.
Mr. Chairman, we will. Thank you.
Representative Zwanzer.
Thanks, Mr. Chairman. Dumb question. How do you know you have an error rate when you're the ones responsible for putting in the data? Is there an audit check and they come through all of your files? And how often is that procedure? And is there a window where we do need to become 100% compliant in the next so many years?
Mr. Chairman, Representative, each month when an agency enters their NIBRS data, they first enter it into what we call the test system. And then it will tell them if they have errors. So for example, if they put in, if it's a substance abuse incident and they count the drugs as items or units, but it should have been weighed because it was a powdery substance, it's not units, that would be an error that would come back. And so those are things that we're catching in our test system before it then gets pushed to the live system and we push it to the FBI. So Wyoming maintains less than 1% error rate. To lose our certification, we'd have to have over 4% error rate for 3 months in a row.
So quick follow-up, what's the amount of time that takes to be doing it all twice then? I mean, that has to be significant to put it in the test system, make sure you're good, and then can you just cut and paste and say we're good, or do you have to retype everything again?
Mr. Chairman, Representative, it's my understanding that once they put it into the test system, then they can just push it to the live system. They're not re-entering all the data.
All right, we got so excited about the Park County data being entered that I forgot about Sheriff Hodge over here on Zoom from Crook County,
Who is compliant?
who was and is. Yep. Sheriff, welcome.
Thank you, Mr. Chair, Madam Chair, committee members. My name's Jeff Hodge, Crook County Sheriff. I think pretty much everything I was thinking was covered. You know, the only thing I would stress is when I kind of learned about people not reporting, some reporting, and I was interested kind of doing my own research and talking to my records clerk. It takes her about 30 minutes per incident to record. So my office is obviously not a small municipal office. It's not a large sheriff's office either. So, but I have somewhat of an advantage. I still have a records clerk, and we're still at the stage where we can use the criminal insight reporter, but we are moving over into Spillman, and I'm getting mixed. Who's a vendor that will compile your data and supposedly make it easier to report. Now I've heard mixed issues with vendors, so I can always go back to Crime Insight Reporter, but these larger agencies that have 200 to 300 incidents per month, that almost puts 2 full-time people every day strictly reporting NIBRS incidents. So that's about all I have to say. You know, we're reporting, we're compliant, we've been compliant. I think it's a great system for law enforcement to look upon, to what adjustments we need to do for, but it is labor intensive, and some of these larger agencies I'm sure are struggling budget wise and staff wise to properly enter all this data. So that's all I have. I'll stand for questions.
Okay, Co-Chairman Nethercott.
Thank you. Thank you, Sheriff Hodge. Appreciate you being here and taking the time and working this issue and sharing with us your experiences. Briefly, are you hearing any kind of, I mean, this is not new, as we just saw from the presentation. This conversation's been going on for well over 10 years, maybe closer to 20, for NIBRs. And then really the implementation's really been in the last decade or so. So certainly the experiences that you have with the vendor and other agencies within the state are not unique to us here in Wyoming. So are you hearing about larger conversations about how this is being resolved or how to make the input of the data easier? And what kind of solutions are you hearing about it on your end?
Sheriff?
Thank you, Madam Chair. The smaller agencies are using crime incident, and that is basically free. It's not very good for, I think, larger agencies because it's taking so long to enter each incident. I'm going over to Spillman, and I've heard good things and I've heard bad things. I've heard some of the old, but I've heard that Spillman is working on making that system more compatible, easier to operate, because I think from what I've talked to and what I've heard is there are some of these record management systems that are just, they're not designed. There's nothing forcing them to do this right when they come out with these systems. But I think the pencil's being pushed. So that will make things better, I believe anyways. I hope. Does that answer your question?
Thank you, Sheriff. Ms. Chambers, were you trying to weigh in?
Just briefly, we wanted to point out one thing, that the web incident editor is what DCI provides for free to the smaller agencies. And we talked about that before. But I just wanted to sort of like formally make a note that I think the question about vendors and the cost is definitely something that pursuant to Representative Yen's follow-up in the next interim. And I think that's something that our agency can look into as far as what federal grants and funding is available and what sort of headway is made on that per your request.
Yeah, Mr. Co-Chair, it's not really about the money. I think it's about forcing those vendors to be more proactive in solving the problems that we're seeing likely all across the country with these challenges with interfacing with NIBRs. So I think, this NIBRs is coming down from the FBI at the request of the sheriffs and chiefs. I get that relationship, but recognizing it all gets reported back to NIBRs. If they want that data to be, usable, then I think they need to put the pressure on those agencies. Besides, they have the heavier hand, right? And they're the one-stop shop right there. And DOJ, which provides most of these services and ultimately that funding, right? It is the agency to work with to put the pressure on, not necessarily getting more money for the state to try to get vendor issues worked out. Just have them do it all across the board. I mean, that would be a thought that I'd have, is just to reach out to those DOJ partners to say, hey, we are not able to meet what your mission is because we can't get these vendors to work with us. Can you help?
Madam Chair, duly noted. To be fair, the reason I brought that up is because what we were told from law enforcement agencies is that vendors have, upgrades that you could buy that would be compliant. So there is anecdotal information that, oh no, we have a robust NIBRs compliant system, but it costs X. So that's why I bring that up, but a very fair statement from you.
Mr. Odekoven?
If I may, I think I can cheat from here. Byron Odekoven, the Executive Director of the Wyoming Sheriffs and Chiefs. Thank you for offering, let me offer a couple of comments. So let me give you an example, if you will, because we've talked about the time frame of 2013 as kind of NIBRs discussion. So for the sheriffs and chiefs, we've had a NIBRs discussion within our annual meeting for years. We've actually had the FBI criminal justice folks to our meetings in Cheyenne several times talking about NIBRs. We have a member, the chief in Laramie, who's been on the committee for a number of years and briefs us at all of our meetings. It's a standard item on the agenda to hear about the criminal justice information system and the issues and concerns. To narrow it down a little bit for like Casper PD. Casper Police Department purchased their first module for NIBRs in 2017. Now you have a records management system to simplify, streamline, and make your records management system faster. So it takes less people. We hear about 30 minutes per report, the number of personnel that would be necessary to enter those reports manually, or you purchase a computer system that will auto-populate many of those fields to where you get down to the last few boxes that you have to manually enter in, but for the most part, those fields are entered. So that's the goal for a records management system, having that NIBRS module. So Casper purchased their module in 2017. They installed it in 2018. It started to work kind of in 2020. Now you have to submit data to DCI for 6 months in order to become totally compliant. You can be entering the data in the test mode in the process before you are allowed to, quote, enter the data on your own, end quote, kind of a thing. So it took them all the way up to get through the vendor issues and problems July of this year. They've been working on it since 2017. They would love to have done it in 2018 when they installed it, would have really liked it to start doing it in 2020 when they could have and weren't able to till 2021. Now the Casper Police Department, as an agency of that size, to manually do the data entry, they figured would take 4 to 6 employees working full time just to enter that NIBRS data to do that. That is pretty cost prohibitive in the greater scheme of municipal budgeting for their law enforcement function. So yes, agencies are waiting for those fixes from their vendors to where they can go to the system where it's 2 people who are checking and verifying that data instead of looking at with the assurances from the vendors every week. Yep, next week we'll have this. You know, next week we'll have this. Next week will be better. But that took considerable time. I'm encouraged since our last discussion and the research the DCI and the Attorney General has been able to do, reaching out to each and every agency, determining where they are. What is the facts of what they're able to do and the cooperation that they've used with the agencies to get that data entered, verified, and make sure that we're in compliance. I think by the time we meet next, I'm pretty sure we may be one of the states that's leading our size and group, I would guess, especially hearing the trials and tribulations of our neighboring states, which I find somewhat interesting, I might add, that they're quote compliant, but they aren't entering data is just a little beyond my thought. Now, we do have, when we talk about compliance, I would remind you that we do have a statute that says that the DCI, the Attorney General's office, will work with agencies to secure that data. So I think we have some of those mechanisms in place for the long term. And I agree, if we can figure out how to get some vendor support, some pressure on vendors to ensure that things go well, that will be better in the long run. I'm encouraged by the information that we'll be able to get out of NIBRS, and I think that will answer many of our data questions going forward so that we don't have to create yet another report that an officer or someone has to do individually and separately to capture the data we'd like to have. Mr. Chairman.
Thank you, Mr. Odekoven. Questions for Mr. Odekoven? One, you want to go back to the sheriff? I do. All right, Sheriff, we got a question for you. Representative Washut.
Sheriff, thanks for joining us today. And my question is, we've heard a lot about how much work it is to get this data put into into your RMS, your record system. As sheriff, do you see this having any benefit for your agency and your citizens in your county? Or is this all an effort in supplying data for the federal government?
Sheriff?
Representative Washut. Thank you. As a smaller agency, I don't think we use these stats probably as much as some of the larger cities and larger counties do, because we are small enough, we can kind of keep an eye on our crime statistics fairly low. So I think it's just an effort to satisfy the federal government on our end. It really, if we've seen a curve nationally, with fentanyl or different instances like that, we're already going to notice that within our jurisdictions. And NIBRS is probably not going to have anything to do with that, honestly.
Thank you, Sheriff. So I guess here's my request to DCI, because I think we've learned a lot. Taking into consideration Representative Yin's comments that we, this may be something that we look at in the interim and taking into consideration what I think I heard Mr. Odekoven say, which was basically you have to do this for 6 months of data entry to be compliant. So what if, and of course, this is just a request, it's obligated statutorily to do it. We know you have to report, but what if we have another report like this generated for us April, May? That's about 6 months from the October, November, where we are now. That's also the time that Chairman Nethercott and I would be, in our committee, would be trying to hone in on interim topics. But I think we learned a lot, and obviously just in having these hearings and certainly in your efforts in reaching out to some of those locals, it's helping and it's working. We're learning more about, what are the vendor issues? What are some of the other gaps? Do you think that would be reasonable?
Chairman, absolutely. I mean, that timeframe is around when you have your first interim meeting for the 2022 year. So absolutely.
Okay. Representative Washington.
Just a comment, Mr. Chairman, the company that owns this RMS system that many of these agencies are struggling with is also owned by a major corporation and provides a lot of radio equipment for the state of Wyoming. And so I think maybe we have some of our own leverage if we decided to contact this company directly and encourage them to assist our agencies forthwith.
Anything else, committee? All right, we sure appreciate you. All right. Title 25. Yeah, let's take a 5-minute break and get stretched and fill up your caffeine for Title 25. Are we live? Well, while I'm welcoming everyone back to our committee meeting, I thought earlier at the 11th hour, I had an outburst on the on Remembrance Day, taking advantage of the 11th hour on the 11th day. And there's a poem here that I'd like to read that was wrote May 1915, following the death of Canadian Artillery Officer Lieutenant Alexis Helmer. And it was written in the trenches during World War I. It's a famous poem. It's about the poppy, which has since become a symbol of hope and remembrance for Remembrance Day. In Flanders fields, the poppies blow between the crosses row on row that mark our place, and in the sky, the larks still bravely singing fly. Scarce heard amid the guns below, we are the dead short days ago. We lived, felt dawn, saw sunrise glow, loved and were loved, and now we lie in Flanders fields. Take up our quarrel with the foe, to you from failing hands we throw. The torch be yours to hold it high, if ye break faith with us who die, who shall not sleep through poppies grow in Flanders field. And that's for your Remembrance Day. And while my co-chairman grabs her coffee. With that, we will move into Title 25. And committee, here's my thoughts, and I've discussed this with co-chairman Nethercott, and we've been talking with the stakeholders and thinking about how we've been approaching this. And what we have is a really big plate full of options. And what I believe we have in front of us is a plate full enough for multiple committees. So we're trying to work Title 25. It's our interim topic. The interim topic, what I'm going to recommend at this moment is that maybe we hone back in on our interim topic on process, which is really what the majority of what we were working towards and what we were tasked with. And we've produced 3 bills, one through our sub working group, the county attorneys who have really worked the process. And then we drafted a couple additional bills last time that dealt specifically with funding. And what I'm going to ask, absent a really strong objection from a committee member, is that maybe the way to proceed is we have these 2 funding bills. That's 22 LSO 0181 and 22 LSO 0183. So the first one is a county attorney's bill, basically with some additional funding put in by this committee, funding policy choices. And then the last one, 0183, is just the policy choice on state funding. And what I think might be the most judicious process, not just for this committee, but for the legislature, would be to set those funding bills aside, proceed with 22 LSO 0112 on process, our sub working group county attorney's bill. And the reason why I say that is because we have a subcommittee in place that has been working. It's a subcommittee that is comprised, it's a management council committee, select committee comprised of appropriators and labor health. And I think it's morphing a little as it goes, but the initial purpose of that committee dealing with substance use and mental health is to address funding, among other things, but it's specifically comprised of the policy component of health, the labor committee, and the financial piece, the appropriators. And so I think that we may be trying to run parallel with an additional committee that's been tasked with something very specific and brings the policy expertise and the financial expertise that maybe Judiciary could have if we had more time, and certainly, half a dozen more committee meetings, but unfortunately we don't. So that would be my recommendation, committee, that will have Mr. Fuller present to us 22 LSO 0112. That is the county attorney's funding bill. And then we'll go into our discussion with our agencies and the public, and then ultimately the committee on that bill. And seeing no strong, eager objections, that's what we'll do. Mr. Fuller, please.
Thank you, Mr. Chairman. 22 LSO 112, working draft 0.5. This is the draft that is based on the, I guess what I would call the final draft that the county attorneys provided the committee right before the September meeting. The staff comment on page 2 outlines the changes that have been made in this bill draft compared to theirs. And primarily, they are numbering conventions and restructuring the order in which some of the statutes are presented. But the substance in this draft reflects what was in the county attorney's draft from September. So with that, I'll just jump right in. Page 3, so what this bill draft does is basically repeals the entirety of the current Title 25, Chapter 10 process. So that would be everything in Article 1 and recreates it in this bill draft. Some of the provisions are identical and are based on current language in statute. Other provisions have either been amended or changed to reflect slightly different or completely different concepts in this. So page 3, line 10, this is a new section that just provides a short title for this act, the Serious Mental Illness Act. Page 3, line 15 is a new section that has the purpose of the act to protect and provide treatment to persons with a serious mental illness and to ensure public safety and welfare. The act is intended to encourage the voluntary treatment of serious mental illness and remove the stigma associated with mental illness generally. Page 4 is a new section for definitions. And I won't go through all of these, but I would note a couple. On page 4, line 20 is a definition for emergency custody. And that term is generally intended to replace the concept of emergency detention that is used in our current statutes. Then page 5, I would highlight the definition of examiner, which lists various healthcare professionals. The staff comment there just notes that the committee may wish to consider whether psychiatrists should be included in the definition of examiner. Under current statute, the definition of examiner, psychiatrist is included, and that's 2510-101A4. And then page 6, line 11, mental illness. This definition means a brain disorder, and this was changed from earlier versions that the county attorneys provided. So it just hones in on the specific mention of a brain disorder that disrupts a person's thinking, mood, or behavior that's associated with distress or impaired functioning. A patient may have a co-occurring disorder of an intellectual disability, drug and alcohol intoxication or addiction, or autism spectrum disorder, but that disorder shall not serve as the primary cause of a condition that necessitates placement in emergency custody, involuntary hospitalization, or directed outpatient treatment. And then mental illness breaks down and includes specific illnesses, and those begin on page 6, line 20. So it's mood and thought disorders, personality disorders, anxiety disorders, degenerative brain disorders, and traumatic brain injuries. The staff comment on page 7 goes back to the intro of that definition of mental illness and a consideration for the committee to move that sentence about a co-occurring illness to a substantive provision in the bill draft. That's just a consideration for the committee. The definition of patient.
Hold on, Mr. Fuller. Co-chairman Nethercott.
Mr. Fuller. Adding co-occurring or substantive.
Mr. Chairman, Chairman Nethercott, the only thing I mean is just to move that sentence, which just says that a disorder, a co-occurring disorder shall not serve as the primary cause of condition necessitating placement. Move that out of the definitions into a different section because it's not, it's, the question would be, is that really a definition or is that a statement of law that should be expressed with the other substantive provisions dealing with the custody and hospitalization of mentally ill persons. And then moving on to the definition of patient, this is the bottom of page 7. It's a person who is placed in emergency custody or involuntary hospitalization or is subject to outpatient treatment. The staff comment is just a question for the committee to consider whether the definition of patient should be limited to persons with serious mental illness, as that term is defined in this draft. Then on page 8, line 19, is the definition of serious mental illness. And this is this means a mental illness where there is a substantial probability evidenced by a recent act, attempt to act, or failure to act, and the person's mental illness and treatment history that the person is or in the reasonably foreseeable future will. And then it goes on to list several different possible actions. So intentionally acting or attempting to commit suicide or otherwise cause serious bodily harm to oneself, to cause harm to others, unable to make rational decisions to meet the person's basic needs, and then be unable or willing to obtain treatment necessary to prevent the mental destabilization that would cause one or more of those 3 conditions. So harming self, harming others, or unable to meet basic needs. The staff comment on the top of page 9 just notes that the definition of serious mental illness seems to contemplate that there must be evidence of both a recent act and something in the person's mental illness and treatment history in order to satisfy that definition. And the committee may wish to consider whether that and should be an or in the event that a person does not have any sort of previously documented mental illness or treatment history. And then moving on to page 10, line 8, the definition of treatment. And the staff comment there just notes whether the committee may wish to consider defining or clarifying what is meant by psychiatric medication. I know there is an amendment that was suggested at the last meeting by a committee member to include reference to psychotropic medication, which I think is maybe more understood term, but it's not necessarily clear, what is or is not a psychiatric medication. Moving on to page 11, line 10, this is a definition of voluntary admittee. And the staff comment just kind of harkens back to the mental illness definition. The second sentence of voluntary admittee states that definition is a voluntary admittee is not in state custody and is not subject to any order issued in accordance with this act. And that may be another sentence that the committee considers moving to a more substantive provision in the bill draft. Under current law, there's a separate section for voluntary admissions that is not present in this bill draft. And then, Mr. Chairman, moving on to page 12, this creates a new section for patients' rights and provides that each patient shall have the right to remain silent. The staff comment just notes whether the committee may wish to consider whether a patient's statements could be used as evidence for treatment and or restraint, as those terms are defined in this bill draft. Moving on, the patient has a right to contact an attorney, an appointed attorney, to represent the patient, to communicate with others unless that communication is specifically restricted in a treatment plan because the communication is likely to be harmful to the patient or another person, the right to receive visitors at reasonable times unless specifically restricted in the treatment plan, the right to be provided with adequate clothing, the right to receive the written copy of the rights specified in this section as soon as possible after being placed in emergency custody. The staff comment just notes that the committee may wish to consider whether that written copy should be provided upon a person's admission to involuntary hospitalization or directed outpatient treatment as well. Page 13, the bottom, and then moving on to page 14, this creates 2510, a section regarding patients' rights and penalties. And so a person who willfully denies another person a right specified by this act is guilty of a misdemeanor. A person who willfully causes the unwarranted custody of a person under this act is guilty of a felony. The staff comment, and I guess before I mention the staff comment, this language is based almost identical to current statute. And it's 2510, I believe 126. So this language, this isn't necessarily a new offense. It's just simply recreated the language here. The staff comment just notes that the committee may wish to specify what is meant by custody, whether that is emergency custody or involuntary hospitalization or directed outpatient treatment or any or all of those above. Moving on to page 15, this is a new section regarding the proceedings remaining confidential. And it provides that the proceedings and records are confidential and shall not be disclosed unless, and then you get a list. Disclosure is necessary to carry out this act. And then it lists disclosure includes disclosure to various entities. So peace officers, examiners, county attorneys, county attorneys, patients attorneys, treatment coordinators, district courts and district court commissioners. And in there, the staff comment on the top of page 16 just notes the committee may wish to consider whether the reference to district courts should only be district courts or if it should include the reference to the district court commissioners. I think that is a change that's been made in this bill draft. And there is language in current statute that discusses the roles of commissioners that I'm not sure is present here. And then the list continues, state agencies and state hospital and so forth. And then at the bottom, any person with a power of attorney that encompasses medical or general health matters. The staff comment on the top of page 17 just notes that for that very last subparagraph, the committee may wish to consider whether more specificity is needed in terms of the reference to the power of attorney. So for example, any person with a power of attorney that provides authority for the person to receive the disclosure of those records and proceedings. Then page 17, beginning with line 11, disclosure may be allowed if the patient or the patient's legal guardian consents, or if a court determines that disclosure is necessary for the conduct of a proceeding before the court. The staff comment, and this is also probably true of existing law that concerns the confidentiality of proceedings and the disclosure of records, but whether there should be some reference to federal law that may be applicable to that situation. Page 17 at the bottom line, beginning with line 31. This is a new section that provides the duties for the Department of Health. And the first subsection A is what the department shall do. And it's monitor the operation and methods of treatment that the state hospital uses, investigate complaints, in good faith, contract with treatment facilities to meet the treatment needs that arise under this act, including the placement of aggressive patients. The staff comment on page 18 just notes that that term, aggressive patients, I believe does not appear anywhere else in the bill draft. So the committee may wish to consider clarifying that term or defining what that term means. The second part of that staff comment just notes that the committee may wish to consider whether the reference to good faith is sufficient, or if there should be some mention to state law or state contracting or procurement procedures. Then not later than 180 days after the effective date of this section, the Department of Health must, and I'm at the bottom of page 18 now, going on to the top of 19, must adopt rules that, and then page 19, line 4, establish and administer a medication review committee that would have at least 3 members who are licensed to prescribe medication in the state. The committee must convene promptly for review after a request from the patient's physicians, and a committee member who is currently involved in that treatment or diagnosis can't participate in this committee's review of medication for that patient. The staff comment on page 19 just notes that the committee may wish to consider whether a treatment coordinator or someone else, a facility administrator or another person, can also request a review by this medication review committee. Right now, only the patient's physician, as this reads, would be able to trigger that review. And then the next part of that staff comment is that for the next 2 subdivisions, the committee may wish to consider whether this medication review committee should be developing the requirements that I'm about to discuss, or if the Department of Health should through rule. And what those are, so now I'm moving on to page 20. The Medication Review Committee would specify what findings the committee shall be required to make in order to administer medication without a patient's consent. And then the Medication Review Committee would establish an administrative appeal process for patients aggrieved or adversely affected by a decision of the committee. And one overall note regarding this Medication Review Committee as is presented in the bill draft. So under current statute, the court is the entity that makes findings regarding a patient's competence to make informed choices regarding, among other things, the need for prescribed medication. And if a court finds a person incompetent to do that, the court may order the administration of certain medication. And then the hospital's Investigation Review Committee, so it would be an entity internal to that hospital where the person is held, then would consider and determine whether the prescribed medication should be continued if it's found medically appropriate. And that committee's decisions are subject to review under the Administrative Procedure Act. So this is a fairly different process that is being contemplated for the administration of medications for patients who are mentally ill. Then on page 20, line 32, this would require the Department of Health to establish a process to submit costs for payment and reimbursement. They must also establish a process for the transportation of patients by rule. This would be the Department of Health still. And on page 21, including rules that specify the entities who are authorized to transport patients, the manner in which they may be transported, including the use of restraints, the transportation to and from facilities in public and private places as necessary to implement the act. Then on the bottom of page 21, beginning on line 20, this would require the Department of Health to adopt policies that establish a process to minimize and manage an admission wait list for placement at the state hospital and a process for voluntary admission to and discharge from the state hospital. The staff comment on page 22 just notes a couple of considerations. And the first would be this kind of concept of requiring the department to adopt policies versus rules, and then the delegation of authority for policies of these specified items. So for example, under current statute in Title 25, statute provides the process for voluntary applications for admission for treatment. Here it would be developed by policy of the Department of Health. Page 22, line 26, are requirements for the Department of Health to post certain information on its website, including the rules and policies that are adopted, a current list of all facilities that the department has contracts with, a current list of treatment coordinators, and a method for the public to request and receive automatic notifications of rule and policy changes. The staff comment just notes the committee may wish to consider whether this requirement is necessary in light of notice requirements for rules, at least under the Administrative Procedure Act. Page 24, line 1 is language that authorizes the Department of Health to deposit all monies and earnings that are received and collected by the state hospital into a special revenue account. And then it provides that any single capital project that exceeds $200,000 must be approved by the State Building Commission. And then an annual report to the Joint Appropriations Committee. This language is based on current statute. It's lifted almost verbatim from that section. The staff comment just notes that the committee may wish to consider the current statutes for capital construction projects rather than this separate $200,000 limit. But again, as I would note, this is current language that's just being recreated here. Page 25, these are the state hospital duties and responsibilities. It requires the state hospital to admit each patient who is ordered by a court to hospitalization and provide equivalent or better patient placement for that patient. The state hospital may administer prescribed medication to a patient without consent in accordance with the rules governing the Medication Review Committee. And the staff comment just notes what I've already discussed in terms of this Medication Review Committee and its rulemaking, and as opposed to currently this decision being based on a court's findings and then determinations of the hospital or institution's investigative review committee for continuing any prescribed medication. Page 26, the state hospital may admit a person seeking voluntary admission. If adequate treatment for a mental illness can't be provided at a state penal institution, the state hospital may admit an inmate subject to the hospital's admission rules. And then the state hospital shall not discharge a patient admitted from a state penal institution without an order from a court to do so. Page 26, line 15 are responsibilities for treatment facilities. They must admit persons. So here, each treatment facility shall admit persons seeking voluntary admission for treatment. If they don't have a available bed, then the treatment facility shall refer that voluntary admittee to other available and reasonable treatment options. The staff comment on page 27 just notes the breadth of that requirement that's imposed on treatment facilities to accept all voluntary admittees if there's space available. Page 27, subsection B, a treatment facility shall not attempt to dissuade a voluntary admittee from seeking and obtaining treatment or place a voluntary admittee in emergency custody. The staff comment just notes that the committee may wish to consider whether there is a situation where a voluntary admittee may need to be placed in emergency custody and how that process should be outlined. Page 27, line 31, a treatment facility cannot place an unconscious person in emergency custody and cannot place a person who is medically unstable in emergency custody unless the person is going to immediately leave the treatment facility. The staff comment on page 28, considerations for the committee would be whether medically unstable in that paragraph 4 above on page 28 should be defined or further clarified, and whether clarification is needed for the placement or actions for an unconscious person who may also have a serious mental illness. Page 28, line 20, this is a new statute for patient attorney responsibilities. It requires the attorney who is representing a patient to accept service of process, represent the patient until the case is dismissed or the court allows the attorney to withdraw. Representation for purposes of this section includes representing the patient in all judicial hearings and any appeals taken from the Medication Review Committee. The staff comment on the top of page 29 just notes that the committee may wish to consider this section, which imposes duties and responsibilities on attorneys in light of the Wyoming Supreme Court statement that courts have expressed inherent power and authority to regulate the practice of law. Page 29 just notes that a subsection B, a patient's attorney is an advocate for the patient and not the patient's guardian ad litem. And a patient's attorney may consider the patient's apparent understanding of legal and medical matters. The staff comment just notes that that sentence, I'm not really clear what is meant by that, and so the committee may wish to consider clarifying that. At the bottom of page 29, going on to page 30, county attorney responsibilities. And this requires county attorneys in the county where a person is placed in emergency custody to review requests submitted by examiners for proceedings. If the county attorney determines that a request to continue emergency custody meets the intent of the act, the county attorney shall file a petition in the interest of the patient and shall appear at a hearing. And the county attorney shall represent the state in all cases proceeding under this act until the court dismisses a case. Page 30, beginning with line 15, this is a new section for treatment coordinator. And I was remiss in going through the definitions to mention treatment coordinator, but this is my understanding with treatment coordinator is that the intent of this is to replace the concept of the current term gatekeeper. So this would require each treatment coordinator to appear at hearings and provide recommendations to the court regarding a patient's custody and treatment, to monitor all proceedings for the patients they're assigned to, provide assistance to achieve timely and effective treatment. If a patient resides in another county, this is on page 31, there are duties for a treatment coordinator to basically be in contact with the treatment coordinator in the county where the patient resides. Page 31, line 19, this is a new section for reporting requirements, and it allows the Department of Health to establish any reporting requirement to track activity under the Act through rule. And then any rules shall require an entity to report only on matters within the entity's direct scope of involvement. The staff comment on page 32 just notes that the committee may wish to consider whether reporting requirements should be spelled out in statute or is appropriate to be left to rule of the Department of Health. Page 32, this is a new article, and this is really the substance of the bill, and the substantive provisions that concern emergency custody and involuntary hospitalization. This first section, beginning on page 32, line 18, just notes that emergency custody, involuntary hospitalization, and directed outpatient treatment constitutes a continuum of a process continuum. And at any hearing that's held under this act, the court must consider whether the requirements for custody or hospitalization are met and order accordingly, except that a court can't order a patient to be placed in involuntary hospitalization at an initial hearing unless the patient and the patient's attorney consents. The staff comment on page 33 just notes that the committee may wish to consider whether there's a need to address a situation where a patient lacks the capacity to consent at an initial hearing, and how that would work. Page 33, line 16, while in the state's custody, a patient must be placed in the least restrictive and most therapeutic facility available. Line 23, if it's necessary to prevent immediate and serious physical injury to the patient or another person, a licensed physician may administer medication without the patient's consent. Page 34, a peace officer may transport patients subject to the act in accordance with the transportation policy of the peace officer's agency. And the first staff comment on page 34 just notes that it's not clear how this subsection fits with the earlier language in the bill that requires the Department of Health to promulgate rules regarding the transportation of patients. So the committee just may wish to consider keeping those two in mind as it considers the bill. And then page 34, line 17, says that no person or entity shall be liable for injury to a patient that occurs while transporting a patient by reasonable means. And then the staff comment on the bottom of page 34 is just for the committee to consider whether that immunity, if you will, should make clear that no entity is liable for any damages occurring during or resulting from transporting a patient under this act. Bottom of page 34, any motion for a hearing under this act must include an evaluation report. That's a term that's defined in the bill from an evaluation that was conducted within 3 days of the date the motion's filed, except for a motion to dismiss. Then on line 5, page 35, before the expiration of an ongoing placement, any party may request a hearing for the court to determine whether the patient still has a serious mental illness or whether continued custody or hospitalization or outpatient treatment would be appropriate. Page 35, line 12 says that the court shall hold an expedited hearing on any motion filed by any party under this act. The staff comment just notes the breadth of that requirement on the court to hold expedited hearings on any motion that's filed. Page 35, line 25, a patient may waive any hearing set under this act if the patient, the patient's attorney, and the county attorney consent to waiving a hearing and the entry of some stipulated order. And here the staff comment on page 36 just notes the committee may wish to contemplate a situation where a patient is unable or lacks capacity to waive any hearing. I think it's currently drafted. That hearing would never be waived. Page 36, line 15, the court may continue a hearing set under this act only for good cause. I think a question there is how that may be reconciled with the requirement to hold an expedited hearing that was on the previous page. Then page 36, line 18, if a court finds that a patient doesn't have a serious mental illness, the court must release the patient from any requirements and dismiss the case. Line 23, except during the initial 72 hours of emergency custody, if an examiner determines that a patient no longer has a serious mental illness, the examiner must promptly submit an evaluation report to the county attorney, and the patient's attorney and treatment coordinator states that the patient no longer has a serious mental illness. The county attorney may object to releasing the patient based on that finding. If the county attorney doesn't object, then the facility must promptly release the patient. Or if the county attorney basically provides in writing that it won't object to the release of the patient, the facility is required to release the patient. And then after a patient is released, the county attorney must file a motion to dismiss. The staff comment on page 38 is just a committee motion to consider whether the court should be responsible for issuing orders for the release of patients if the county attorney fails to object or provides notice of no objection. So what would happen if the county attorney is silent, as contemplated on the previous page? And then the next part of that staff comment is the role of the treatment coordinator in determining whether a patient has or no longer has a serious mental illness that requires emergency custody or involuntary hospitalization. Page 38, line 15, a patient who's discharged or otherwise released ceases to be in the state's custody. And then finally, when a patient is discharged, the facility holding the patient must make arrangements to transport the patient back to the residence, or if a transient, to the community where the patient was initially placed in emergency custody. The bottom of page 38 is the section now concerning emergency custody, and provides that if a peace officer has reasonable cause to believe a person has a serious mental illness and the person refuses to voluntarily consent to go to a facility, the peace officer may place a person in emergency custody. Subsection B is an examiner. If an examiner has reasonable cause and won't consent to transportation or examination, the examiner may place a person in emergency custody. Page 39, line 13, no person with a serious mental illness shall be placed in emergency custody unless the person won't voluntarily be transported to a facility or remain at a facility. And then the staff comment on page 40, the committee may wish to consider whether there should be some reference to treatment to that. So the patient, so for example, the patient will not voluntarily consent to treatment. After a person, this is on page 40 now, after a person's placed in emergency custody, an examiner must notify the person, both orally and in writing, of the patient's rights that were outlined earlier in the bill. When a person is placed in emergency custody, a peace officer or examiner must promptly prepare a report. And then the rest of page 40 going on to page 41 is what the contents of that report. Then on page 41, line 11, the person who prepared that report must submit it to the facility, the county attorney, and the treatment coordinator. The staff comment on the bottom of page 41 is whether notice should be given to the patient's attorney as well of that emergency custody report, and whether the identity of the treatment coordinator would be known for purposes of submitting that report. Page 42, an examiner is required to conduct a preliminary evaluation of a patient within 24 hours of placement in emergency custody to determine whether the patient has a serious mental illness. If no evaluation is conducted in that 24 hours, the facility must promptly release the patient. If the examiner determines that the person doesn't have a serious mental illness, then the examiner shall promptly release the patient from emergency custody. If an examiner determines that a patient does have a serious mental illness, emergency custody can continue for not more than 72 hours. And then this gets into some of the new language that was not an existing statute regarding how you calculate the 72 hours. So it excludes weekends and holidays. And if someone is placed in emergency custody on a Saturday, Sunday, or legal holiday, the 72 hours begin at 8 a.m. the next business day. An examiner is required to submit a written summary of that evaluation to the facility, the county attorney, and the treatment coordinator. And the summary shall identify at least the provision for which the patient's condition qualifies as serious mental illness. So harm to self, harm to others, failure to meet basic needs. Page 43, line 16, this is a new section for continued emergency custody. Under current law, this language is included in the current section for emergency detention, which I believe is 2510-109, H through N. So this language just requires for continuing emergency custody, the county attorney must file a petition and include the emergency custody report and that written summary that was previously required. It then goes on to talk about service of process. The staff comment on page 44 just is a note for the committee to consider specifying after what time limit a patient's placement in emergency custody that it may be continued. So after X hours or after the limit specified, the 72 hours, for example. I think at the very least, some of this action must take place in the first 24 hours in terms of that emergency report and that preliminary evaluation. This requires the court to hold a hearing on that petition within the 72 hours. If it's not, the patient must be released from emergency custody. If the court finds after the hearing that by a preponderance of the patient has a serious mental illness, the court may continue emergency custody for not more than 21 days after the date of the hearing, or until another date that's specified in a stipulated order to continue emergency custody. And then if the court finds that the patient doesn't have a serious mental illness, it must order the patient released. Page 45, line 8, at least once a week, an examiner must conduct an evaluation and submit a report of the patient. The staff comment on page 45 just notes that the committee wishes to consider whether that report that's conducted at least weekly should be submitted to the court as well. If there should be a process for a patient to seek termination of continued emergency custody before the end of the period in the court's order, or if the patient should be released if the evaluation, this weekly evaluation, shows that the patient is no longer suffering from a serious mental illness. Page 46 is the section concerning involuntary hospitalization. This is 2510-110 in existing statute. Just requires the county attorney to file a motion to seek that involuntary hospitalization. The staff comment there on page 46 just notes, the committee wishes to consider whether, an evaluation report is submitted within 3 days of the expiration of a placement order, depending on how the calendar may fall and how those requirements line up. And then in subsection B below, the committee wishes to consider whether an examiner may give testimony about the person's serious mental illness. So page 46, line 25 says that if after hearing testimony from a licensed physician, the court finds by clear and convincing evidence, so it's a higher standard, one that reflected in current law, that the person has a serious mental illness and that involuntary hospitalization is the least restrictive placement available, the court may order that involuntary hospitalization. Page 47 just provides what can happen during involuntary hospitalization. So any party can request a hearing to determine if it's still appropriate, and then provides for periodic reviews and reports every at least 3 months after a patient's first place, and then every 6 months thereafter, reports and the current treatment plan for the patient and a recommendation for the least restrictive placement for that patient. And then at least once every 12 months, the court must hold a review hearing to determine whether the patient still has a serious mental illness. The bottom of page 47, moving on to page 48, is directed outpatient treatment. This is referred to as directed outpatient commitment in current law. This just authorizes a court, if a person has a serious mental illness based on failure to meet the basic needs, or a person won't seek treatment to correct issues that lead to one, harming oneself or others. The court may order the patient to directed outpatient treatment if it's appropriate and the least restrictive placement available. Before ordering a patient to outpatient treatment, the court must approve an initial directed plan, and then a treatment coordinator is required to supervise directed outpatient treatment. And at least once every 6 months, the treatment coordinator must submit a treatment report to the county attorney and patient's attorney and specifies what should be in that report. The staff comment on the bottom of page 48. The committee may consider clarifying who is required to submit that treatment report in light of the hearing, if that report should be submitted to the court, and if so, who submits it. It's unclear from the previous language, but on page 49, line 7, at least once a year, the court must hold a hearing to determine whether the patient still has a serious mental illness and if directed outpatient treatment is still the least restrictive placement available. If an examiner, this is page 49, line 13, if an examiner determines that a patient has not complied with a directed outpatient treatment order, the examiner may place a person in emergency custody. Page 49, line 20, this is a new section concerning minors. and a number of these provisions are new and aren't necessarily contemplated in current statute. So page 49, line 20 provides that a parent or a guardian must obtain treatment for a minor's mental illness or serious mental illness in the same manner as any other illness, injury, or health condition. The staff comment on page 50 just notes that under current law, the parent or guardian of a minor or incompetent person may consent to treatment. And if a parent or guardian doesn't consent, then a petition may be filed, a neglect petition may be filed under the Child Protection Act. The committee may wish to consider whether that requirement that's placed on parents is better suited for Title 20, or excuse me, Title 14. And then the language of a statute regarding the protection of parental rights is included for the committee's consideration in light of that language on the previous page. Page 50, line 31 just notes that a minor may consent to treatment the same as any other healthcare treatment that's provided in 14.1, 101B. That's included on page 51. The situations in which a minor may consent to treatment. Page 51, and then moving on to page 52, just notes that if a minor is placed in emergency custody, the facility holding the minor must attempt to notify the parents or guardian the minor's in emergency custody, where that person's held. If they can't reach a parent or guardian, or they don't hear from a parent or guardian within 24 hours, the facility must report the placement to the Department of Family Services and to the county attorney for that county. The staff comment just notes that the committee may wish to more directly clarify which county attorney, whether it's the county attorney for the county where the minor is placed in emergency custody or the county where the minor resides, for example. Page 52, line 27, this is a new section that requires the Department of Family Services to obtain emergency treatment for a minor in its custody with a mental illness or serious mental illness in the same manner as any other illness. The staff comment there just notes that the committee may wish to consider whether the language in that section would somehow allow a minor to be placed in DFS custody with only a mental illness as opposed to a serious mental illness, given that reference that's on the bottom of page 52. Page 53, line 19, this is the final article that's created in this bill draft and concerns costs and financial liability. Page 53, line 21, this keeps, generally speaking, the current structure for costs with a couple of differences. The county in which a patient resides is liable for costs in the first 72 hours, excluding weekends and holidays. The staff comment on page 54 is just maybe the committee may wish to consider clarifying who is responsible for the costs of emergency custody when the 72-hour period begins or is interrupted by a weekend or holiday. I'm not sure that's clear from the draft. Then the Department of Health, consistent with current law, is liable for costs incurred after the first 72 hours of emergency custody. If a patient is not a Wyoming resident or is a transient, the department is liable for all costs that are incurred under this act. Page 54, line 26, the state and the county shall not be liable for any costs incurred by a voluntary admittee or for any costs incurred after a patient becomes a voluntary admittee. Page 55, this concerns third-party liability. A lot of this is familiar to current law. Just requires a facility to attempt to recover all costs from any and all third-party insurance and benefit programs that may cover those costs for that person. And then page 55, a facility is deemed to have fulfilled that requirement to seek third-party payment if it certifies that the patient has no insurance or all insurance is denied coverage for any remaining costs. The patient's not covered by a benefit program. And then page 56, third parties specified in this section, so benefit programs and insurance, are prohibited from requiring pre-authorization for emergency medical and serious mental illness treatment during emergency custody. The staff comment there is just a note that the committee may wish to consider whether that conflicts with any of the requirements of say, an insurance or benefit program, or whether that may impermissibly impair existing contracts that require the contrary to what that language spells out. Then page 56, line 22, each county in the department has a right of subrogation. Page 56 is a new section that says that except as provided later on in the bill, no treatment facility or state hospital shall bill a patient personally for costs that are incurred under the act. And then third-party insurance and benefit programs remain obligated to provide all benefits that the patient's entitled to. Page 57 is a definition of costs, and they include all costs associated with the treatment of serious mental illness, transportation, clothing, care, supervision, and other services, but exclude costs that are associated with treatment for medical conditions that are not directly caused by a patient's serious mental illness. And then this page 57, line 18 and 19 is would be a new requirement. It says that costs shall be equivalent to the state Medicaid rate. The bottom of 57, expenses shall be billed the same as for a person who is not subject to this act. And then costs incurred by a voluntary admittee shall not be covered under this act. And here the staff comment just notes that the committee may wish to consider expressly saying that a voluntary admittee is directly responsible for any costs that are incurred. Page 58 is a new section for fees, and they are defined to include legal costs and fees for a patient's attorney. The staff comment just notes whether the fees for a patient's attorney includes fees that are incurred after the first 72 hours that a person is subject to emergency custody or another form of custody under the act. The county in which a patient resides is liable for fees. So that would be the legal costs and the attorney costs. For patients who aren't Wyoming residents or a transient, then the county where a patient was placed in emergency custody would be liable for those fees for the patient's attorney. Page 59, now we're getting into amendments to existing statute. The first change on page 59, lines 18 and 19 is just a conforming amendment to correct references. Page 60, line 4, this is a definition in the Child Protection Act and would add to the definition of ordinary medical care to mean emergency mental illness treatment. This was a change that was included in the county attorney's draft. The staff comment just notes whether that change is within the scope of this bill draft that's focusing on amending provisions to Title 25. And then also the committee may wish to consider whether emergency mental illness treatment should reference serious mental illness treatment in light of the use of that term throughout the bill draft. Page 61 are amendments to definitions in Title 35 that this is the 2021 House Bill 38 changes. And these just correct, really these just are conforming changes to reflect the change in nomenclature that's used in this bill. So emergency custody, correcting the statutory references, directed outpatient treatment. The same at the bottom of 61 is just a note, is just a change from the reference to gatekeeper to treatment coordinator. Then moving on to page 62, this repeals Title 25, Chapter 10, Article 1. So it repeals that entire article that currently exists for the treatment of mentally ill persons. Page 62, line 13 is the applicability section. So it applies to any person who's placed in custody or hospitalization on and after the effective date. Applies to any person who's believed to have a serious mental illness. It applies for the purpose of calculating and reimbursing costs and fees. Moving on to page 63, this act would not apply to any person for whom emergency detention proceedings, involuntary hospitalization proceedings, or outpatient proceedings have been initiated before the effective date of this act. And then for persons who are specified, who are basically are kind of in the process already, the current law would apply to them still. Page 63 is rulemaking for the Department of Health. And then the effective date would be a split date. But then the staff comment just notes that the bill mentions not later than 180 days after the effective date of the section. whether more time should be given or a further delayed date should be contemplated for that rulemaking process to be completed. With that, Mr. Chairman, I'll stand for questions.
All right. I'm not sure who needs a break after that. Definitely Mr. Fuller. Thank you, Mr. Fuller. Committee, where do you want to start? You have questions for Mr. Fuller? Co-Chairman Nethercutt.
Mr. Co-Chairman, thank you. I think probably the most important piece of this bill likely resides in the definition of serious mental illness. So you know, because the entire act lays on that definition, or how that then interplays with the entire process that's laid out. So it's my thought that we focus our attentions there first for what is a serious mental illness, with the subparagraph to be added for running for political office. Certainly should be appropriate. But candidly, I do think that that particular definition needs to be worked very carefully, in that there, if we look at that staff comment found on page 8, which is where that definition is found, I think the staff comment is correct. And I also think it's important to recognize that it appears to be my interpretation that not only does there need to be a substantial risk of danger to themselves or others, but there also has to be this connection to a mental illness in order to be involuntarily hospitalized. And I think that that is different than how the law currently operates. That really the dispositive factor associated with whether one should be involuntarily hospitalized is whether or not they are a danger to themselves or others. Not that that lays upon a finding of a serious mental illness. Am I correct in that understanding, committee members, audience, Mr. Fuller?
Mr. Chairman, Chairman Nethercutt, under current law, mental illness is a physical, emotional, mental, or behavioral disorder that causes a person to be dangerous to himself or others, and which requires treatment. And then danger to himself or others is defined, which would be the substantial probability of harm to self, to others, unable to satisfy basic needs, or a mental health. Actually, the final one is the court may consider a person's mental health history in determining whether it's warranted.
So Mr. Fuller, follow up, Mr. Chairman. Under current statute, if you are a danger to yourself or others, you therefore have a mental illness as defined by statute. Is that correct currently as an interpretation?
You know, Mr. Chairman, Chairman Nethercutt, you know, that definition does say, you know, a physical, so a disorder which causes the person to be a danger to self or others.
So that's incorrect. So you have to have a disorder, one, and then two, that disorder causes this. So it's very similar in concept to how this works. This one is just more spelled out with the emphasis on having a serious mental illness. All right, thank you, Mr. Fuller.
Senator French?
Yes, I've got a couple of questions. On page 14, line 8 through 12, it states a person who willfully causes the unwarranted custody of a person under this act is guilty of a felony punishable by a fine not to exceed $5,000, imprisonment for not more than 5 years or more. Who determines that? Who says I wrongfully or unwarranted to put committed somebody? How does that process play out there?
A jury
Co-chairman
of your
Erica?
peers, Senator French, a jury of your peers.
Yeah, but who brings that to the jury or to the, who starts that process? I mean, they say, okay, Mr. French, you had an unwarranted hold on somebody. Who tells me that? Who says that?
Representative Oakley does.
So an investigator from, so law enforcement would do an investigation and then they would provide their investigative findings to a prosecutor who would then make a charging decision whether or not to move forward with charging. So Representative Oakley or Representative Craigo would make those decisions whether or not to move forward with charges.
But somebody says, okay, I think there was an unwarranted hold placed on this person. Do they go to the county attorney and say, I think this was not correct? Do they go to a judge? Do they, who do they go to say, hey, I have a suspicion that this person was wrongfully committed?
You go
And
to
then,
Senator French, law enforcement would have to investigate that, a certified peace officer. So you'd call the police. They would investigate and provide a report to the county attorney. If you called the county attorney first, they would say, call the police, have them do a report and provide that report to me. So it would be just like any other kind of criminal case where law enforcement is contacted about a suspicion of a crime, to report a crime, and then they do an investigation and provide that report to the prosecuting attorney. Representative Oakley, would you like to give any more insight into how you do it?
Does that help, Senator French?
I'm still a little confused on that. It's, okay, they're in the system. They've been involuntarily committed by somebody. And then can anybody say, hey, that smells, that isn't right? How's that play out? I'm struggling with how that plays out.
Representative Oakley, take a crack at that.
Thank you, Mr. Chair. So anytime anybody wants to believes they have evidence or thinks they have knowledge of a crime, they can report that to law enforcement agency. That's how all investigations are done for any criminal act, which is then, of course, important because then they would have to find probable cause before anything comes of that. So if perhaps, I don't know if I'm hearing right, your concern is, anybody could make allegations. That could happen with any criminal act, but law enforcement would have to find that there was some substance to it to pass it on to a prosecutor, who then also would have to find probable cause. They would be charged. Then, of course, they would have to be found guilty by a judge or jury. It's just the same as any other criminal act.
So any officer can say, or somebody can report to them, they shouldn't have put a involuntary commitment on that guy. That wasn't warranted. So they would go to the police or the county attorney and express their concerns, and then they would follow up on it.
Mr. Chair. Yes, that's correct. It's the
Okay.
same as anything in that realm of what would be considered a criminal act.
Okay. My other question, if I may, Mr. Chair,
Please.
page 42, line 18 through 24, and then on page 43, lines 2 through 5, they talk about the emergency custody of the patient may be continued for not more than 72 hours. And the 72-hour period excludes weekends and holidays. So they would start on the the Monday at 8 a.m. How does that jive with on page 53 that the county is liable for 72 hours excludes weekends and holidays? So how do those jive with each other? Maybe Mr. Fuller can, because if, okay, there's a, we're not going to start this till 8 a.m. the next day, but maybe there's 3 days, a weekend and a holiday day before that 8 a.m. starts. If anybody can clarify that for me.
Mr. Fuller.
Yep. Mr. Chairman, Senator French, I think that's the purpose of the staff comment on the top of page 34, or excuse me, on page 54. I think as it currently reads, it's not clear who pays for the weekends and holidays if the 72 hours exclude that from the calculation of that 72 hours for cost for the county.
Would it, Mr. Chairman, if I may again, would it be simpler if it just stated the county is responsible for 72 hours? Just do away with the weekends and holidays, and then the state would have to pick up that end of it.
Go, Chairman.
Madam Co-Chair.
Commissioner French, I'm sure that the counties would appreciate that effort, but I think that
Yes.
I think that the intention is for the counties to pay for that time, because the definition really, I think, is intended to be 72 hours. 72-hour period excludes holidays and weekends, and that's how it is to be interpreted. So that reference to the 72-hour hold, excluding that, the counties would be responsible, I think, for up to 6 days, potentially, maybe longer with a holiday.
Right. My point being that it gets, as a county commissioner for years, and we had to budget for Title 25. Those 6-day holds were very expensive, and I mean horribly expensive. So I just think the county shouldn't be liable for up to 6 days. Just my opinion.
Okay, Representative Yin.
Mr. Chairman, just a question on process, maybe. There are 50 staff comments. They all have very important considerations. And I wonder, is that something that we plan to do for tonight?
I'm sorry, state the beginning of your question again.
Mr. Chairman, there are about 50 staff comments
Right.
that have important considerations that I think we should consider. And I wonder, I mean, I guess it's just a question for the chair, what we think the process for this bill should be.
Well, we could just start working it, I suppose. We could go page by page and hit those. We could touch each comment. It's gonna be a long night. Yeah, go ahead.
Thank you. It is 4:36, and I mean, I think it would be reasonable for us to continue at least for another hour and work the bill, an hour and a half-ish. We are scheduled for half a day tomorrow, so there's a little bit of flexibility there, I think, with us still being able to get out. So if we think about it, can we work the bill in 2-3 hours? Potentially, and I think that we probably can. And so if we think of our time that way and recognizing there might be some time tomorrow as well. Committee's thoughts about that, co-chairman's thoughts about that? You all have plans Friday afternoon?
Yeah, and I mean, we're gonna obviously see what we have in public comment realm as well that we want to bring in
Sure.
before we start to do that. Representative Washington.
Thank you, Mr. Chairman. Just along the same lines that you just mentioned, I think we've had folks waiting here to testify. We should hear their testimony first. Let them go home, and then if we want to work till whatever hour tonight, we can.
Well, and that's true for tomorrow too. I think that my co-chairman's point is that once we've taken the public comment, we can get that. Actually, if we can get the public comment in tonight, we can close it and we can work the bill. We can even work the bill tomorrow,
Right.
depending on how far we want to go tonight. I think that's how we'll proceed. So right now, what we're doing is, so two things. Right now, we are just finishing up any questions we have for Mr. Fuller on the presentation of the bill. If there are no questions on the draft of the bill, then we'll take public comment. And, I think the last conversation is probably the best highlight of what my opening comments were intended to avoid. Was, yes, we absolutely could talk about funding for a very long time. And it is a very important conversation. This is a big conversation. The intent in my opening comments was to try to narrow the scope of our discussion to this bill, to the process and the procedure, which is what is really being addressed with this bill, and not bog us down in both the policy of the finances and the policy of the procedure questions. So,
Yeah.
You take that as you will, committee. Obviously, you're at will to discuss what you want, but it's really hard for this committee to discuss these two monster areas of consideration, given the time that we have. So bear that in mind as we move forward. Are there any other questions, I'm sorry, for Mr. Fuller? Senator Cole.
Thank you, Mr. Co-Chair. Yeah, particularly double back on the serious mental illness question. I had heard that there's some sort of history that had to be, reviewed or understood or known. I kind of looked the definition up and I kind of wonder where that came from. Is that some sort of CMS issue? Could you elaborate on why serious mental illness can't be evaluated at the time they're brought in as being a danger to themselves or others? Thank you, Mr. Co-Chair.
Mr. Fuller, you know that history off the top of your head?
Mr. Chairman, I do not. I think that may be a question better suited for the county attorneys.
Okay. We may have an answer to that question, Senator Kolb. When we dive into public comment, we'll just try to remember it.
One last question. For Mr. Fuller.
We have one last question for Mr. Fuller from the co-chairman.
Mr. Fuller, on page 6 is the definition of mental illness. And then page 8, we have the definition of serious mental illness. Can you explain how those two definitions interplay in the bill just generally?
Mr. Fuller?
Mr. Chairman, Chairman Othercott, the way I understand it is that a serious mental illness is a mental illness as that term's used in the bill draft. And, one note there is, whereas under current law, the definition of mental illness is, I think, just a social, emotional, physical disorder. Here, it spells out, it means a brain disorder. So I think that definition, that is a difference that's in this bill draft compared to current law, which I think leaves it far broader in terms of what illness or disorder triggers, the person to be a danger to himself or others.
And follow up, Mr. Fuller, too, in looking at that definition on 6, it's my interpretation of this definition that somebody who is simply intoxicated and not suffering from an underlying mental illness, but is suicidal, would they qualify for involuntary hospitalization?
Mr. Chairman, Chairman Othercott, if the only thing that a person has is drug or an alcohol intoxication or addiction, I read that on lines 16 to 18 shall not serve as the primary cause of a condition necessitating placement.
Which is costs are going down.
All right, Mr. Fuller, thank you again. Should we move to let's get any additional comments that we may need from our county attorneys. I know our main representative is not available. Who do we have from the county attorneys?
We have Mr. Beaver, Mr. Chairman.
Okay,
He should be on Zoom.
he's online. Welcome, Mr. Beaver.
Thank you, Mr. Chairman. Yeah, as you noted, Charmaine Reed, who's the main drafter of our draft that we submitted, it wasn't available this afternoon, so you'll have to just put up with
Mr. Beaver,
me. There we
looked
go.
like what we looked like when we first started into our digital world of Zoom meetings. Half of us set our computers right at our forehead.
I appreciate all the work that Mr. Fuller's done and his presentation to you this afternoon. I didn't get a chance to count up the number of comments, but I think 50 is probably a pretty good estimate. And I would just share with the committee that in my review, probably about half of those would be ones that we would consider to be positive, constructive suggestions that we'd certainly encourage the committee to do something with. Probably the other half would be things that we would disagree with and would just assume the committee not make any amendments for. But it is voluminous, and I just want to be available for you in whatever manner that would be constructive. I do have a Title 25 hearing tomorrow at 10:30, so we've got to be done by then.
Maybe we should zoom into that.
Mr. Co-Chair.
Go ahead.
Mr. Beaver, thanks for being here with us. Have you identified the staff comments that you could email to us that you agree with?
I could send you an email, yes.
That'd be helpful. And then did you hear my question associated? My primary concern is that I think as the bill is currently written with the definition of mental illness, that someone who is suffering from severe alcohol intoxication and is also suicidal or homicidal could not be involuntarily hospitalized unless they also had some type of identified underlying mental illness. Is that how you interpret it as well? And what are your concerns about that?
Yeah,
If any?
Mr. Chairman, Senator Nethercott, your observation is accurate. Your hypothetical of someone who comes into the ER intoxicated, if that, even though they're suicidal and intoxicated, does not qualify them for Title 25. They would have to be diagnosed with a mental illness as the primary issue. And that is the current law. We've worked with the differing two definitions, mental illness versus serious mental illness. And if you'll recall, we explained that early on. We're trying to remove the stigma associated simply with the term of mental illness, and by adopting the serious mental illness terminology that would qualify for Title 25. But conceptually, nothing's changed. It's exactly the same standard as it would be today.
Representative Washit.
Thank you, Mr. Chairman. Mr. Beaver, is the same standard then in place for the law enforcement officer who's making this call on the street, determining whether or not he has lawful authority to take this person into custody? Has anything changed in this rewrite from existing law in terms of that peace officer? Does that officer now have to have some evidence of mental illness, or is the threat sufficient to justify bringing the individual in?
Mr. Beaver.
Mr. Chairman, there's no intent in this draft to change from the current situation as far as law enforcement. Typically, if they see somebody who's intoxicated, for whatever substance they've abused and are suicidal, they're going to bring them to the ER and let the medical people make the call as to the diagnosis.
You look like you wanted to say something, Mr. Beaver.
Could you hear me?
Yeah. we heard you.
Okay,
Oh, I thought you were just going to continue with your thought. Sorry.
No, I was just trying to keep track of my little mute button on and off.
Okay. Thank you. Other questions for Mr. Beaver? Hmm. Representative Craigo, you get nothing, huh? Co-chairman Nethercutt.
Mr. Beaver, what is the consensus among all the county attorneys about how they feel about this bill draft? Do you know?
Mr. Beaver.
Mr. Chairman, the input that we've had from the various county attorneys was to the draft that we gave you at the last interim meeting. I have not gotten feedback from anyone with regard to the draft that you're working through today, with the staff comments and so forth.
And can you remind us again, Mr. Beaver, what the consensus was at our last meeting from them?
Yes, the president of our association told us that we could represent that there is general approval of the draft.
Remarkable. Attorneys do agree. Thank you, Mr. Beaver.
Honestly, though, Mr. Beaver, it does make me think a little about, it makes me a little nervous because we have, as we've identified, 50 staff comments that have not been vetted by your association, which would make me a lot more comfortable with those staff comments. Because if the bill without any change in staff comments is essentially the bill that we have a general consensus from your association on, and then if we adopt the wrong 3 or 10, whatever it may be, I don't know how to, I mean, we're going to receive an email from you that gives us a general idea of at least your thoughts on some of the comments that are acceptable. Is there any other way you see that we proceed with that other than we're in session and we address it then? The comments that will come from your association, I assume, at that time?
Yeah, Mr. Chairman, during the session, there would be additional input.
Okay. All right. Did you have something there? No? All right. Thank you. I thought, nope. Anything further for Mr. Beaver? Representative Craigo, thank you.
So, Mr. Chairman, I guess my only comment, and it's not really a question, but my comment is if we're going to actually work this bill later tonight and tomorrow, it'd be helpful if Mr. Beaver sticks around so that we can actually ask him questions about the staff comments. Because the email, if we end up working it tonight, the email is not going to be helpful. I need to know why, sitting here, why do you not agree with this staff comment? Just to tell us they agree with these ones is not going to be that helpful to us as a committee. We need to know why you don't agree with the other ones. That's more important to me.
Mr. Beaver, anticipating doing that, but he has a hearing tomorrow. When's your hearing tomorrow? You said in the morning?
10:30 tomorrow morning. So I'm available to you until then.
Or after? Do you think, because it would be the afternoon, I think, Mr. Beaver, that we would take up working this bill. Would you be available in the afternoon?
I would.
Okay. I think that makes us a little more comfortable. Well, what additional public comment are we going to receive tonight? Stefan, we have stepped aside from the funding portion, but you still have some comments, I assume? Briefly, okay. Do we have any other questions for Mr. Beaver? If not, who else is going to testify on this bill? Andy and, yep, association. Okay, let's go with Department of Health. Start there. I noticed the conference in the corner doesn't want to touch this quite yet.
Mr. Chairman, members of the committee, my name is Stefan Johansson. I'm the interim director for the Department of Health. I'll keep my comments brief. Most of my comments today were around the bills that are not being considered with relation to cost. To Co-Chairman Nethercott's point before on the definition of serious mental illness, that is something that we've expressed in previous committee meetings on this topic that might create confusion, given that it is a clinical definition that's often used in mental health treatment that really does not have anything to do with an individual manifesting dangerous behavior, homicidal behavior. And often there are folks with SMI, as we call it, that do not require or need civil commitment and voluntary hospitalization. That's not the operative intent of the definition in this bill as we read it. Obviously, it is someone with serious mental illness in this bill is manifesting those behaviors that are dangerous to themselves or others. That strikes me as very reminiscent of current statute. And all of these statutes for civil commitment around the country are bad. Some are better than others and all create confusion. But with the kind of operative intent of current statute, I think that's what's at play here with the definition of serious mental illness. Our recommendation would be to use language that's more along the lines of civil rights statutes, which define why a person can be detained or involuntarily hospitalized, which would be those dangerous behaviors. I know that brings us back in that definition to kind of what is in current statute. And I understand the intent of the drafters of this bill is to clarify some of the conditions that might create those behaviors that are dangerous to the individual or to others. But we do think that could create confusion in the clinical sense and some potential interpretations that anybody with serious mental illness or SMI, as we say, can be detained or involuntarily hospitalized. And again, I don't want to be misunderstood. I realize that's not the intent here, but it's almost as if we in Wyoming would be creating a new definition of serious mental illness when it is already operative in the clinical context. In addition, Mr. Chairman, I would mention that in the definition in this bill of mental illness, including things like degenerative brain disorders, does dramatically broaden the conditions within which someone can qualify, for lack of a better term, for Title 25 proceedings. That does create some concern for the department, given that there's obviously a cost issue. I won't go into that. But there's also some complicated issues related to what we call Institute for Mental Disease definition for various types of reimbursement from the federal government. Certain facilities that are considered IMDs or Institutes of Mental Disease that are primarily responsible for treating mental illness, et cetera, including folks with dementia, organic brain syndrome, that can put funding at risk for certain facilities. So we just wanted to bring that to the committee's attention. We don't have a suggestion on that yet, other than potentially scaling back some of the conditions that are included in there. However, we understand that in practice for a county attorney or a judge or a local community, they are often dealing with individuals who might be elderly and dangerous or aggressive or violent. That I think the intent is to seek out some clarity in statute of when or not those types of individuals can be titled. I do think that has some confusing elements within this bill draft. And finally, Mr. Chairman, before I stand for questions, I would just express some minor concern. It's more questions from the department standpoint of what the Medication Review Committee is intended to do that the department would be required to establish. I think I understand the broad intent, essentially to provide advice or decision-making to physicians or practitioners who may be evaluating or treating patients who are under a commitment of this nature when involuntary medication needs to be prescribed. To have the Department of Health or a committee with at least 3 people be available at a moment's notice when requested by a physician, that could create some timelines that I think everyone in Title 25 practice gets frustrated with when you can't get someone into a facility, when an examiner is not available. This could create an additional layer of complexity when what is a timely manner for the department to convene that committee to make recommendations on medication administration. That would be something we would have to work through significantly in rules. And also, since we are a big selfish Department of Health, I don't know what capacity we would need internally to be able to achieve that. If it's additional duties for staff that we already have that would be able to convene in a timely manner, or when requested, that could be a provision in the fiscal note that we would draft if this bill were to move forward. I don't want you to hear me say that that is an impossible thing to do. We have committees somewhat similar to that across the department, and we would certainly be willing to work with this body and our local communities to be that resource. But just to clarify for the committee, that is an additional duty, an additional burden on the department, as some other things in this bill are. For example, the court having to hold annual hearings on folks that are committed. We do have folks who get committed under Title 25 and then are in a treatment facility like the state hospital for more than 1 year, multiple years, unfortunately, in some cases. And that is currently not required by statute to have the court have an annual hearing. I believe patients or their attorneys can request that. And the state hospital is currently required to regularly report to that specific court or county attorney on the status of the patient and the continuing need for hospitalization. So again, I know it's late in the day, Mr. Chairman, Madam Co-Chair, so I did want to keep my comments brief and happy to stand for any questions.
Questions for the Department of Health? Representative Grego?
Thank you, Mr. Chairman. Again, and this, I guess I'd echo my comments from just a few minutes ago in regards to the County Attorneys Association and Mr. Beaver. This bill is so big and there's multiple questions that we could address to the director, but at this juncture, I mean, to go down through every single one of them becomes very difficult. It'd be much easier as we're working the bill if we were able to go back to a few of these people and ask them specific questions. How does this apply here? How does this apply here? But in the abstract, for us to just start picking off little things, I don't know if it's beneficial. And so not really a question for the director, but again, the question might be, would he be available for questioning? Help us out as we start working the bill.
Mr. Chairman, if I may, Representative Craigo, I will certainly make myself available to this committee. I am detained, to use these bills terminology, tomorrow at the Joint Labor Committee meeting most of the day,
Right.
but we'll be in the same building, so happy to try to stop by if possible and answer questions.
We'll just have to see if their subpoena trumps our subpoena.
I would just also say, Mr. Co-Chairman, it's unfortunate that we just fell back with time, and so it feels much later than it is, but it is one bite at a time, right? That's the only way we're going to take out this elephant. So I do think if we can just even start with some small pieces that we can get addressed now, that is progress, instead of just deferring it all to tomorrow. Otherwise, you're not going to get out early at all. So if you do have some specific questions that he can answer easily that you think are low hanging fruit, I think we should probably get some of those answered now with the folks testifying that are right in front of us right now and take advantage of this unique opportunity. It's only 5 o'clock.
Co-Chairman Nethercott's right. For members from a process standpoint, I actually hesitate to when we are working the bill, allow for public comment. And the reason behind that is fairness. So, we haven't noticed that we would have additional public comment tomorrow. We may be talking with our county attorneys and our Department of Health, but what about the rest of the public or other associations or other agencies that desire to have that same process. It's generally not our process. Our process is to take public comment, close public comment, and work the bill. Out of fairness, that public comment has to be noticed. So, you know, it is unfortunate that we are running out of time, but you know, it is 5 o'clock and being a part-time legislator sometimes means that you just keep working until the work is done. This happens in the interim, guys. It's not unusual. So I think that we should get as much information as we can in from the folks that we can, with the intent that what we're doing tomorrow is really working the bill as a committee. And I think you also have to just appreciate that it's not the last opportunity in the process, obviously, to continue to gather more insight. So with that, if you have questions for the director, now is a wonderful time to do that. Representative Washington.
Thank you, Mr. Chairman. Interim Director, could you identify maybe 3 of the staff comments that cause you the most concern while you're here tonight?
Mr. Chairman, Representative, happy to do that. I can't do that on the spot. I would need to go through each one of them now.
Representative Yin.
Mr. Chairman, thank you. So maybe I'll just pick one that I noticed. There's a staff comment on page 34 on rules about transportation, right? So a peace officer may transport patients subject to this act in accordance with the transportation policy of the peace officer agency. And then you have the staff comment on, does this conflict with Department of Health promulgation of rules for transportation of patients? And I wonder if you had any thoughts on what should take priority there. What do you think the process should be? What is the process in the current Title 25? Thank you, Mr. Chairman.
Director.
Mr. Chairman, Representative Yen, currently transportation reimbursement or transportation itself of patients under Title 25 commitment is handled through Department of Health policy mostly. With reimbursement, we have a Title 25 policy manual for providers. I think the intent here, which is well taken, is to further codify that through rule, which has the force and effect of law. And so we would be happy to take that on, essentially taking what are policy measures now, if we have the legal authority to do so, and codify them through rule. Exactly what happens when a patient needs to be transported either from facility to facility or discharging from a facility. Statute currently governs that after 72 hours for residents and the entire process for non-residents, the Department of Health is responsible for transportation of the patients. We handle that, Representative, in 2 ways. One is through our transportation teams at the state hospital who deploy out of Evanston and drive all over the state to take patients from one location to another. Again, whether that's an interfacility transfer or from a facility discharging to home or what have you. But that's a limited resource, obviously, with physical transportation. So we also do reimburse for providers who arrange for transportation of a patient, whether that is with one of their own vehicles, with a taxi, with a bus ticket. And it's certainly not perfect. It doesn't cover all of the costs. It's essentially pegged at the Medicaid rate for medical transportation. But that's currently how it works. And again, within what is directed in the bill, we would take the time that's allotted to codify what's necessary in rule.
Thank you, Director. Ms. Somerville.
Thank you, committee chairman, committee members. Andy Somerville. I'm the executive director for WAMSAC with the Community Mental Health Centers. And we too have a lot of comments, but I'm going to hit some quick highlights for you guys. And I'd be happy to share any additional information through email. And just to say, I too will be over at the Labor Health Committee, but I'm happy to run back and forth tomorrow for the committee if needed. So we wanted to start out the conversation just to say that starting on page 6 with the mental illness definition and the serious mental illness definition on page 8, we agree with Director Johansson. There is a lot of confusion with those terms. I'd be happy to provide the committee with what those clinical definitions are. But again, I think the intent of the Title 25 statute is to really establish a definition by way that somebody can actually be detained. It's a common problem. In fact, we had this discussion when House Bill 38 was being constructed as well. Mr. Chairman, the next page that I want to hit is page 26. Towards the bottom of that page, line 15, treatment facility responsibilities. This paragraph, while we understand the intent, we want people to be, if they're voluntarily seeking treatment, we want them to receive treatment. The concern that we have is for our facilities, we have 4 crisis stabilization centers in the state that are run by community mental health centers. They all have a little bit different capacity and ability to detain or to admit certain types of patients. For example, they're not locked facilities. They don't have restraints. So there are clinical considerations to the admitting of a patient, not just whether there's a bed availability. And in reading this particular paragraph, we weren't entirely clear that those kind of considerations would be considered reasonable. So if somebody presents and the crisis stabilization center does have a bed, however, clinically or medically, they don't meet admission criteria, we need to be able to help them find another place that is appropriate. And so we just want to make sure that that type of flexibility is included in that paragraph. So we're not forcing facilities to take patients that aren't clinically appropriate for their type of equipped facility. Mr. Chairman, I would move to page 46. And this would be line 25. Just want to emphasize that we agree with this, the staff comment referring to hearing testimony from a licensed physician. Given the number of Title 25 evaluations and gatekeeping that the community mental health centers do, we are most often the ones in court providing testimony. And so we would think it would be prudent to maybe move that to after hearing testimony from an examiner to reflect better, again, what actually happens on the ground. And Mr. Chairman, moving to page 47, directed outpatient treatment. The comments we had are generally positive for this section. In the continuum of care for trying to provide treatment, directed outpatient commitment is a tool in our statute right now, but it is not currently used very well or very often, frankly. It's just very rare for somebody to be put on a directed outpatient commitment. In conversations with state hospital staff, other types of providers and other stakeholders, really using a DOC to keep people in the community is the best way that we have forward. So I would encourage you to keep this section as it is written in the bill right now, and can maybe we'll continue to review it and look for maybe some more tweaks before session if the bill gets that far. But we would really like to see this as more of a use tool to keep people in the community, maybe before they get out of the state hospital, or potentially people that might be clinically appropriate to come out of the state hospital, but still need some type of commitment in the community, again, with the goal being to get these people back into their communities whenever possible. And then, Mr. Chairman, page 61, and these are just general comments in terms of where this draft is going. We certainly appreciate the intent of Title 25 reform and revision. It's very important, but we just want to remind the committee, House Bill 38 passed last session. That is a major community mental health reform. That bill prioritizes community mental health centers to do gatekeeping as part of a bigger kind of mental health reform. We are prioritizing populations that are at risk of being titled, have been titled, all of those things for community mental health centers to really zero in and serve. And so I appreciated the correction in this bill, which doesn't completely take out that gatekeeping language that was from the last meeting. So I appreciate that. And just remind the committee, we are continuing to work on, as stakeholders, the reform of the entire continuum of care from start to finish. But this Title 25 is very important. So with that, Mr. Chairman, I would stand for any questions.
Questions for Ms. Somerville?
Mr. Co-Chair,
Co-Chairman Nethercutt?
Ms. Somerville, WAMSAC, generally, are you in favor or opposed to the bill?
In general, we're in favor of the bill.
Vice Chairman Costa?
Thank you, Mr. Chairman. In regards to voluntarily, is that something that's a large manner? I mean, I'm looking at it and saying there should be some kind of an evaluation or something before they are even coming in. I'm a little concerned about the way that's written in here. Do you have any concern with it or not?
Mr. Chairman, Senator Cost, so in terms of voluntary admittees, that is something that we encounter occasionally. People that have decompensated, they end up in the ER or in law enforcement's custody, and either through a little bit of time stabilize and realize in a moment that they do need treatment and they're willing to go seek that treatment. The risk is always whether we voluntarily admit them at that point in time and can get them into the right type of facility versus them potentially decompensating an hour or two later, where they all of a sudden now won't consent to treatment, don't want to go anywhere. And so it's a delicate balance of trying to, at the end of the day, get somebody into treatment the way they are. We certainly see with the voluntary admittees being precluded in this draft, we could see the need where we admit somebody into a facility, they're willing to go, and then they decompensate, and now we're having a Title 25 question again, instead of just doing the Title 25 when they volunteered to go into treatment in the first place. That's, Senator Cost, really a process question.
Representative Rodriguez Williams.
Thank you, Mr. Chairman. Ms. Somerville, I'm looking at page 18, line 12, and wondering if you can provide some guidance in regards to the language that is under the staff comment, aggressive patients. Do you have a suggestion on some more appropriate verbiage?
Ms. Somerville?
Mr. Chairman, Representative Rodriguez Williams, unfortunately, I don't have tonight a suggestion to directly replace that. We would recommend that if this is going to be tied to a requirement for the Department of Health to help place patients, that we do find a different term than aggressive patients. That's not something we would normally see either in a clinical sense or in statute. And what you're really talking about is meeting clinical needs of the client versus clinical capabilities of the facility where you're putting them. That's really what you're getting at right there, because it could be maybe low range aggression to somebody that's literally tearing things apart, depending on what's going on. But I would be happy to check in with a few more people and see if I can find something to send you guys by tomorrow.
It's helpful. Several of us keyed into that earlier and scratching our heads. So good question. Please.
Mr. Co-Chair, thank you. I mean, I think what it's driving at is when it's difficult to find, a placement for an individual who needs it because they're exhibiting those signs that there's no real clinical placement, or they don't want them, right? Because they're aggressive, which is why the county attorneys identified that word. It's really not the other issues, right? It's the fact that they are violent, which is how they got involuntarily hospitalized to begin with. And most facilities aren't there. So how do you typically identify or describe a patient that is violent?
Mr. Chairman, Madam Co-Chair, to the best of my personal knowledge, we would describe them as a client with violent tendencies, but I would be happy to double check that with my clinicians.
And one word to just consider, Ms. Somerville, is violent patients, right? I mean, potentially.
All right. Thank you.
Thank you, Mr. Chairman.
Man, she sneaks in there right at the end, I swear. Representative Provenza.
Thank you, Mr. Chairman. Just a real quick question for you, Ms. Somerville. it sounds like based on some of the staff comments on when medication can be forced to patients, that there might be a concern about like patient rights or the rights of someone who is competent and can make decisions about their medical treatment. Do you see, how do you see this language? Do you agree with that? Is that going to be something that's problematic for centers? Just any comment on that would be helpful for me. Thank you.
Ms. Somerville?
Mr. Chairman, Representative Provenza. So I don't know that I could give you particularly maybe the comments you're looking for. So forced medication is something that we've always obviously done through the other process. And it often across the state for community mental health centers involves other stakeholders, namely the hospitals that have psychiatrists on staff. That is not something that a lot of community mental health centers do. However, we are always concerned about patient rights. That is a very important piece of the mental health system. And I would just encourage additional conversation and potentially looking at resources maybe from protection and advocacy or other groups that specialize in the other side of patient care.
All right. Thank you.
Thank you, Mr. Chairman.
Hospital Association?
Mr. Chairman, members of the committee, Josh Hannis with the Wyoming Hospital Association. I'm going to be very, very brief. My concerns initially were around the reimbursement pieces of the bills. I'm glad to see that those will be considered elsewhere. I think there is a more appropriate arena for those. I do have one lingering concern, and perhaps I'm reading this wrong, and I'm happy to be told that I'm wrong. So this particular piece of legislation says, the counties are responsible for costs for a particular period of time, the state's then responsible. And then on page 57 on lines 18, it seems to define costs and putting them in statute as the Medicaid rate. That causes us a great amount of concern. And if, our suggestion would be is that if we could eliminate that little Romanet 3 from the definition of cost and basically leave reimbursement, as I think was the chairman's purpose at reimbursement at status quo for now, and then have a review at another time.
Questions for the association? Vice Chairman Washit.
Thank you, Mr. Chairman. Otherwise, is the association a supporter of this bill?
Mr. Chairman, Representative Washit, we have no other comments on the bill at this time.
Okay. Thank you. County Commissioners.
Good evening, Mr. Chairman, members of the committee. I'm Jeremiah Riemann here on behalf of the Wyoming County Commissioners Association. I'll keep my comments as brief as the others. First and foremost, the primary concern for commissioners, of course, is always the health, safety, and welfare of their communities, of their constituents, and certainly of the providers that exist in the community. And from that perspective, we have discussed this particular legislation through our Health and Social Services Committee, and they have expressed their support. Now, I haven't been able to take it to my full board. We won't do that for a little bit, but I think that that would lend some support to seeing this legislation moving forward. Certainly, the financial concerns are a secondary piece of this. I'll respect the wishes of the chairs and the committee here today, but it's certainly that uncertainty that exists for anybody, whether that's the state or whether that's my commissioners, is also a concern. But again, the foremost concern is for the health, safety, and welfare of people. And from that perspective, the commissioners seem to really appreciate this legislation and what it can do.
Committee questions for the County Commissioners Association. All right, well, we appreciate that. We fully appreciate the reality of the funding conversation and the need to continue to have it. And do we have a DFS representative on Zoom? Because I have, I feel like I have one signed up for public comment on my sheet.
You know, Mr. Chairman, I'm not sure if they're online still or not. You know, I know they were only going to be available to answer questions. I would note that I think we do have one additional commenter on Zoom who would like to comment.
Is that the doctor from the WBI? Okay. Let's bring him in. Or he's already in, he just needs to turn on his camera. Welcome,
I
doctor.
couldn't turn it on until I got permission. Hello, Mr. Chairman. I'll be not as brief as most of the others, unfortunately, but there's a lot to cover. I'm not speaking on behalf of WBI. I'm speaking as kind of an expert in this field. Just to give you an idea, a bit about my background, I'm triple boarded in psychiatry, neurology, addiction medicine, and preventative medicine. Can you hear me?
Yeah, can you hear me?
Yes.
Hey, doctor, can we just start with your name, please?
Sure, David Martirano.
Awesome. Now you can go.
Great. So as I was saying, I'm triple boarded in psychiatry and neurology, addiction medicine, and preventative medicine and clinical informatics. I've worked over the past 10 years at WBI, at Wyoming Medical Center, briefly at CWCC, most of the nursing homes in Casper. So I have a lot of experience in these areas. I've cared for 5,000 patients here in Wyoming, 6,000 emergency detention hearings that I've been an expert witness in 7 different counties. I've also been involved in over 1,000 commitments to the Wyoming State Hospital. So the purpose is from a clinical understanding about Title 25 is that it's to supply care in the prevention of suicide, where we still lead the nation, unfortunately. We are almost triple the rate of some of the more successful states in managing this. The thing that I have probably the biggest challenge with is the fact that we do not have any channels for managing substance use disorders, none. And specifically, it's excluded in the language. However, it's one of our biggest cost centers, both in terms of human cost and in financial cost. Some examples I can give you are patients who've been through the medical center and WBI. I have looked at our high utilizers, which I would say are people who've been admitted to WBI over 6 times. 112 different patients I looked at. That most of those people had on average 20 admissions over the 10-year period. These people, the vast majority, have substance use disorders that go untreated and are not, there's no law around how to help these people in recovery. As a result, they come back suicidal time and time again. They go through Title 25 process and they just recycle. I estimate that those individuals alone resulted in approximately 5,600 patient days, 700 admissions in total. In my work with WMC, I've seen even more problematic cases, people who've had up to 600 admissions at Wyoming Medical Center over a 25-year period with unmanaged substance use disorders. Come in for detox, go back out, come in for detox, go back out. That patient I mentioned, it's about $2 million in care for that one patient that if they'd been in some way directed outpatient committed to substance use treatment, the person could have gotten help, gone on to a meaningful life. Instead, we end up in these same problems. So then I just want to move on to the challenges with directed outpatient commitment. Okay. Earlier, one of our other guests spoke about the fact that directed outpatient commitment should be used more widely. The language around it is so confusing that we're not able to access that. I have a patient right now, I have 2 patients actually, who we've been trying to get onto directed outpatient commitments for the last 90 days. And because of a lack of ability for the district or the attorney general and the actual community mental health center to coordinate that patient has resided at WBI at high cost and with no benefit to the patient, but no ability to step down. That's the biggest problem. We don't spend the money efficiently. And this Title 25, you're going to lump a bunch of stuff together. But what I'm going to hear in all these hearings and what I've heard for years is we can't do anything about this person's substance use. We can't involuntarily medicate their medical disorders. I noticed that you guys have continued the language on not medicating just for psychotropic medications as opposed to all medications. I have people in WBI who are diabetic who attempt suicide by hyperglycemia and refuse insulin, which we can't administer involuntarily, even though we've already determined this person doesn't have capacity. It takes months to indefinitely to get a guardian for the person. And so we have no ability to advocate for this patient's safety. And I'm unable to get that. Also with eating disorders, there's problems with the statute doesn't provide any means for treating people in terms of nutrition. I don't know whether it wants to specifically exclude that, and I leave that up to the legislature to determine what the most appropriate course there is. The challenges, again, are it's a huge burden on the ERs. I have other issues with the current system, which that it doesn't really reflect the capacity is not an on-off switch. You don't go from one day, even in what I heard today, I've been listening since you guys came into session, and what I heard today was a general concept that, you know, serious mental illness goes away. Serious mental illness doesn't ever go away. It comes under control gradually, and stepping people down to the appropriate level of care is a gradual process. But we don't have a good, I also was reading through the bill and trying to understand it, my doctor level understanding, but the challenges that I see are that the bill comes into play and then requires the Department of Health to come up with a plan to manage all this, as opposed to first requiring the Department of Health to come up with the plan, then having all the stakeholders agree on how all that's going to happen, and then moving on to enacting the plan. It seems to me that, and this isn't, I'm not trying to point fingers again, in terms of cooperation, if we're all going to work together, I think that we need to see what the plan is first before writing law that says we're going to have a plan and then you're going to follow it, because who's responsible for that plan? And so I also, the Hospital Association comment on Medicaid rates, I hope that language gets left out. And then there's also this exclusion of autistic persons. And I've had huge problems in emergency rooms over the past 10 years when somebody is autistic, and that's the primary problem in terms of their violence and danger. And how do I help them? And I've had county attorneys bounce it back saying, well, this is not one of those areas. This person should go into DFS custody, and DFS saying, we don't have any ability to take care of this person, put them at WBI. So the other thing is, and this is a huge one for me, is that there again is this provision about there needs to provide a mechanism for voluntary admission to the state hospital. Okay, the state hospital, the as best as I can understand it, and I've gone into this at great length with various parties over the last 10 years, the state hospital already has a means for voluntary admission, but it prioritizes involuntary admission. Right now, we have patients who've stayed at WBI on state hospital commitments for 150 days. Those patients are getting care at WBI, and that's great. However, as the state hospital always has a wait list for involuntary patients, unless admission to the state hospital happens and you continue to use designated hospitals as the place where a patient who's voluntarily admitted to Wyoming Behavioral Institute. So what I'm saying is, if you're saying we don't want to go with involuntary detention for people who voluntarily want help at the Wyoming State Hospital, that admission could start at a designated state facility and be under the auspices in the same way that we do current commitments to the Wyoming State Hospital. But without that, there isn't really a mechanism. These people would have to linger indefinitely. If I had put somebody on this list in 2011, when I started at WBI, they'd still be at WBI, not admitted to the state hospital, because the state hospital has never not had a wait list. They've always had a wait list for involuntary, and they prioritize those. if we streamline that process for voluntary admission, I think we could get rid of about 30% of the involuntary hearings in general. So if we just had a means for people to apply and be accepted for commitment to the Wyoming State Hospital or voluntary treatment at the Wyoming State Hospital, but within our other designated state facilities, we could get rid of a lot of this. The other questions I have is that the costs around I've never been compensated at all for being an expert witness on all of these hearings, although I'm court ordered to appear at them. It would be nice to know who's supposed to pay for that after 10 years. But the other question is who also funds all these reports that you guys are putting in there? Because the preparation of reports is a time-consuming process, and you're asking professionals to do that. That no longer has a serious mental illness I already covered, sorry. There's always been kind of a discontinuity between what the Department of Health and CMS require and what Title 25 requires. And it would be nice if somehow those were also reconciled. The final thing is that there's a lot of talk of mental illness in this, and I just wanted to bring forth O'Connor versus Donaldson, the Supreme Court decision in 75. You can't confine somebody for a mental illness by that finding. So you have to confine them for dangerousness of some sort or grave disability. We seem to get away from this term a lot, but that is what the Supreme Court ruled back then, and that's never been revisited to my knowledge or overturned in any way. So I think we need to be careful about that. That's it. Thank you. I tried to be as quick as possible.
Well, thank you, Doctor. Representative Washit.
Thank you, Mr. Chairman. Doctor, I appreciate you hanging with us all day and listening in and giving us your view on things. I'm curious about the substance abuse issue, the recycling of cases over and over and over. Is there a level? Because I don't think we're going to do it on the first time somebody shows up with a substance abuse issue. Is it 3 times that they get admitted, 5 times that they get admitted? When should the red flag go up? If we make it too early, it's going to be way too expensive and we're not going to be able to manage that, and then the workload will get crazy. But is there a point where they would meet a threshold on repeated cycling?
I would say 3 times in 12 months or 5 times in 24 months would be a very nice guideline for that. I think that would be ideal. I think that, yes, I agree with you entirely that we don't want to be compelling people who are able to succeed independently. However, there should be some mechanism for solving this problem.
Any other questions for the doctor? We really appreciate you. It's late in the hour and you stuck with us and you really provided us with a lot of comments. So we really do appreciate that.
Thank you, Wallen. Thanks for all your hard work on this. And I really do appreciate the work that the county attorneys have done in putting this forth. And I think their definitions are excellent. It's really a lot to do, but I hope that you guys will continue to look at the psychiatric community as possibly a resource for you to help you on some of these areas, because we do deal with this all day, every day. So happy to help when I can.
And Doctor, it looked like you at some point you may have been reading from something. Is it possible for you to forward some of your notes?
Sure. Yeah, let me clean them up a bit. But yeah, some of them aren't complete sentences. I was just trying to have bullet points. But yes, I will be happy to put that together and get it off to you guys tomorrow.
That would be wonderful. When it's not so late in the evening, we'll be.
Where would you like me to send that?
It's 5:30. But it's not so early in the evening for my co-chairman and late for some of the rest of us. But
is there an email address for me to send that?
Yeah, you can just send it to Mr. Fuller, and then you can distribute it to all of us.
Mr. Fuller, do you have an email address? I don't know if I.
Well, I think they've got a contact info with you, Doctor. So they'll chat. Okay. Now.
Okay, great. I'll make sure that he gets it then. Thank you so much.
Thank you so much. All right. Back to additional public comment. Yeah, or our conference.
Wait.
All I'm doing is looking out for my fellow senators. I know that 8 a.m. is an early start time. 10 a.m. is a more reasonable time.
Mr. Chairman and Madam Chairman, Rick Lavery, District Court, Third Judicial District in Green River. Chairman Olson mentioned that we weren't saying anything, and I just wanted to say, happy to answer questions. I don't know that I have a lot to add. I commend everyone for making the effort to improve Title 25. It's been a rough slog for a lot of years. I would mention, I guess, just briefly that the definitional change of mental illness from what really was a legal term and not a medical term to now more of a medical term is substantially different, but it may be better. It's hard to say. And I would leave that to the professionals. But the one thing that we have is a body of law that supports that legal definition, and now we're going to change that. The other one was the incarceration of people who fail to or to keep somebody. I'm not sure who that applies to. A lot of times law enforcement take people into custody for Title 25s. And so then is law enforcement going to prosecute law enforcement? And so, and does that kind of create a chilling effect for people getting out there and doing the right thing? But clearly people with mental illness are not to blame for their circumstance, and we got to do what we can and be the best we can be for them. So I applaud the effort. And if you have any questions, we're happy to visit about it.
Questions for Judge Lavery? Representative Washington.
Thank you, Mr. Chairman. Your Honor, what amount of work does Title 25 create for the courts?
It's different in every district, but I will say that the process has streamlined over the years. So in a lot of jurisdictions, the initial hearings are done by court commissioners. They go into the 72-hour phase, and you see the hospital, for example, in Sweetwater County will kind of do some triage and get the mentally ill person medicated and back on track, and the case gets dismissed. So it's not a lot. This may create more, but that's not necessarily a bad thing. If we get to a point where we're handling people better. But I think our numbers, I know, have gone down, and I'd be interested. I don't know if Judge Snyder or Judge Blumenthal have a different opinion. But yeah, it's really streamlined itself over the years. So it's been an interesting change.
Co-chairman.
Thank you, Mr. Co-Chair. Thank you, Judge. How much of technology is helpful in these types of cases where a patient is in the hospital? Do you use technology, and how does the technology get used?
We do use technology, and all of our hearings in Sweetwater County take place at Memorial Hospital of Sweetwater County. So the hearings take place there, but we use the Teams, Microsoft Teams application for witnesses and things of that nature.
Follow up, Mr. Co-Chair?
Mhm.
Judge, you indicated the use of commissioners. Can you briefly talk about that, just for a quick overview of what commissioners are, who they are, how they operate?
So court commissioners are appointed by the judge. They work in the county where the judge resides. They can't go outside of the county, but they can do things for the judge. And one of the things they can do is conduct initial Title 25 hearings. They can also do shelter care hearings. It's pretty limited. It's not like a magistrate in circuit court. They have much broader authority, but the problem with court commissioners in terms of expanding on what they can do is they're created by constitution. which would require an amendment.
Committee? Thank you, Judge Lavery.
You're welcome.
It's not that the conference is obligated to comment, of course. It's just, we really do appreciate having you here with us all day and providing insight. It's not something we've always had. I'm sure it's been off and on over our history as a legislature, but I'm finding it very helpful. So thank you. Additional public comment? All right. With that, I was going to close public comment. You have something, Co-Chairman Nethercott? Or can I?
Potentially, just want to put this comment out there, maybe to Mr. Odekoven or others. Senator Cost identified it, and so did the judge, concerning that the criminal, and so did Senator French, the criminal provision associated with an unwarranted involuntary hospitalization. And obviously the county attorneys put that in there because they must be experiencing some type of false reporting, or, you know, where someone calls the police and say he's threatening to commit suicide or kill me or whatever it might be. That person starts the process of being involuntary hospitalized. So just curious about how, if that is happening on the ground, and what that looks like, and maybe how we can tighten that language up so people feel more comfortable if it's needed, and maybe trace it back to that false reporting type concept. Mr. Fuller has an answer for us, I think.
Mr. Chairman, Chairman Nethercott, I don't know if I have the answer. You know, one possibility for why it's included in this bill draft as well is because it's existing statute. It's 25-10-126. It's virtually verbatim. So both of those criminal provisions in the bill draft, I think were just copied from that existing section.
Representative Grego?
Mr. Chairman, I would say it's not exactly verbatim. There's one word that's different between existing statute and the proposed bill language, which is the word custody versus hospitalization, which is actually quite different.
Yeah.
For the purposes of this bill in particular.
Have you dealt with that crime? Representative Craigo, have you dealt with that crime?
No, Madam Co-Chair, I have not.
All right, committee. So had some more time to gather thoughts on how we're going to proceed with this. And I think we've got this window of opportunity tomorrow. And we have Co-Chairman Nethercott is chairing, so she's going to keep us ahead of time. I'm confident with that. So knowing that, we would proceed as the agenda is already published, because those times are set and people have planned on them. And then we're set to finish up our public comment around at 12:30. And we could take up the bill and begin working it at that time. We could work it for a little bit tonight if you'd like. If you'd like to call it quits now, that's fine. And we can begin working it at 12:30. Tomorrow at 12, once we begin working the bill, this is my global thought on that we work the bill. I know we have 50 possible comments that we want to work through. I think we should spend a couple hours, as Co-Chairman Nethercott indicated, and just work through those. I think we'll have comments that will receive from the county attorneys, between now and 12:30, when we start working it. If there's a pressing comment, that Director of Department of Health might want to bring to our attention, a particular one or a half a dozen of them, that, certainly email us. And if not, there's no pressure that you have to identify some at that moment. And I think we work the bill like we traditionally would, and we do it for as long as we can. And if we feel satisfied, and the bill may move forward at that point. If we work the bill and we feel like we're working through these staff comments and there's just a lot there, and we're then pressing against the hour tomorrow, we can always entertain the option then and we'll have to meet with Mr. Fuller because procedurally, I'm not confident on how this would work, but if we could conditionally pass the bill forward with the hope that maybe we could attempt to request an additional 1 day or half day, 1/2 day, sorry, 1/2 day meeting by Zoom for that bill and that bill only. That would require management council approval and it would require funding. So maybe, go ahead, Co-Chairman Nethercott.
Yeah, Mr. Co-Chair, I mean, so that I think has been somewhat discussed and Co-Chair and I also discussed it. It is a robust bill and I want to feel confident about its passage as a joint judiciary sponsored bill, that we all feel confident with it moving forward and what it does and what it doesn't do. So it would be nice to know if that option was available in light of tomorrow being a half day and in light of the proposal that we would only commit another half day on Zoom, right? It's possible that we wouldn't necessarily need significantly more funds associated with having another full day meeting. So it would be all Zoom with everybody. And it would only be a half a day, which would kind of represent what tomorrow afternoon might be. So there is a budget associated with these committee meetings of which we have to stay within. And so we can't just have multiple meetings because we have work to do or we can't get our work done. But that is an option we're considering in order to make sure that this bill looks the way it should, if that's possible, but we can't guarantee that, so.
And I'm throwing that out there right now because committee, what I don't want you to do is agonize over the evening. Start working some of this or be really stressed tomorrow and throw your hands up in the air. I think we work it as diligently as we can and get as far as we can, but this is a very important bill and a very big topic. And if that's what we have to move to is trying to get that extra half day, I think there's time for that. There's a lot of considerations in the universe that brought us to that point. And the last month, obviously, of what the legislature has been in special session and that occupied, obviously, take, for example, the director of the Department of Health's time and his ability to review this bill and provide substantive feedback to us, I assume is limited because of that. And I assume even some of our own time is limited because of that. And obviously our LSO time is limited too. So those are all considerations, but I think that's how I would envision us proceeding. Representative Washington.
Thank you, Mr. Chairman. I concur in your comments. I think that's a good plan. And I just want to remind, especially the House members, that Joint Judiciary worked this topic last interim. And so I feel a real push to bring something forward this year that we're going to have confidence in, as the co-chair mentioned. And I think that we can. I think this bill is way ahead of where we left it last year. And I hope that we can persevere and get this done before February.
All right. With that, let's get some rest. All right. I think, well, unless you would like to work the bill some. You're nervous to make that request.
I'm not, Mr. Chairman, I'm not necessarily making a request to stay and work the bill, but maybe. I guess what I'd like, if we are going to work it tomorrow, is have some decision points and check with LSO and anyone here if there are some questions we need to some work on, some language, some major issues that LSO believes in all of these staff comments. These are the 4 major ones we should be pondering this evening. Which exact pages, no offense to Mr. Fuller, but that's a lot of staff comments. And some of them are important and some of them I think, well, those might, but I don't know enough. So if we do have, another 20 minutes to run through, here's where some language might be needed. Here's a major decision point that's going to be some conversation tomorrow. Let the special interest in the room, if there's something they are really adamant about that we need to change or fix or amend and have some language prepared for tomorrow, I think that's important to spend another 10 minutes on tonight.
Co-chairman.
Mr. Co-Chair, thank you. And I think without putting Mr. Fuller in kind of an awkward spot of deciding what staff comment is more important, but maybe the top 5 issues that you see in the bill, and then recognizing, that's why I focused on the county attorneys. What is it that they like tomorrow? And then we would do the deep dive with everything that they didn't discuss with them live. So we should be getting that in the morning, I think, from the county attorneys who are going through all of those staff comments too, but for us to contemplate tonight, certainly, Mr. Fuller, if you're prepared, maybe top 5.
Mr. Fuller?
Mr. Chairman, I guess the first comment I would make is I am, the staff comments throughout this bill draft are just identification of issues for the committee to consider. I don't want to put my thumb on the process. I also don't want to, give my opinion, I guess, in terms of what is or is not important for the committee to this, to focus in on. I think the discussion that's been had has identified some of the issues that certainly are worthy of the committee's consideration. The definitions of mental illness and serious mental illness. I think there is some work to be done with the costs in the bill draft, as has been highlighted by various speakers. I think the process of the medication review committee is another topic that has been brought up. The rulemaking process for the Department of Health and how that looks, particularly with transportation and the potential conflict with, can peace off, if who says, what peace officers have to do when there's a statute that says, what they can do. Beyond that, I think Representative Crago identified an issue with that criminal provision. I think there's a staff comment for that in terms of what is meant by custody, that difference. Beyond that, I'm not sure I want to opine or go further to say what the committee should or should not focus on, in regards to this bill draft.
That's actually perfect, Mr. Fuller. That list is, and I think that is an awkward position for you to be in. Your fingerprints are obviously all over this bill because you drafted it, but I understand your position, and that's what I was keying into as well. We've already, and maybe I wasn't being clear enough, but we've had enough comment to understand at least some of those that are bubbling up, and that was my intent of my directions to the Director of Department of Health and I don't know if our county attorneys are still listening, but the idea that tomorrow we would receive Representative Zwanitser's kind of more refined list, but that meant, mental illness obviously bubbled up to the top very quickly as an example. And I think the rest of your list is an appropriate as considerations as well.
Mr. Co-Chair, if I
Yes,
might,
please.
I think the length of the bill and the number of staff comments seems overwhelming, but really when you break it down and you read the staff comments, they're not particularly complex. And so I do think if we just start working it tomorrow, that it is not unmanageable. I really don't think so. Particularly in light of the subject matter experts who will be available to provide further assistance. So I think we're able to accomplish it and we shouldn't feel too much anxiety. I think the way the bill started out was a lot to hear and take in and track for 50 pages worth. But I think we can manage it.
And there's always one more bite at the apple in the legislative process, which our stakeholders are fully aware of. I mean, to be honest, they know how this process works. So I think if we were to adopt certain provisions that they need to stew more over on, even if they don't at this point, they may say that sounds good to us, and then we adopt it, and then 3 months later, they don't like it anymore. So that, that happens. That's just part of the process. All right. That being said, does that helpful, Representative Zwanitzer? You can sleep sound tonight peacefully.
Mr. Chairman, I will probably lay awake all night thinking of those complexities and having answers tomorrow. So I probably won't sleep soundly thinking about.
We appreciate your continued service to the Judiciary Committee in the state of Wyoming, Representative Zwanitzer. Thank you for that. Anything else? Anything else, committee? Representative Washit?
Privilege of the floor, sir.
Privilege granted.
Thank you, Mr. Chairman. While I don't hold a candle to Representative Winters, I got text message a little bit ago. My 15th grandchild was born today, so I'm feeling pretty good.
Maybe we'll find root beer floats tomorrow in the. All right. Thanks for sharing that with us. That's really special. All right, committee, with that, we'll be adjourned. Till tomorrow at 8:30 a.m.